Hey folks, I think we're ready. Can everybody hear me on this mic? Not yet? We're going to turn it up a little bit. How about now? Any better? Better, yeah. Better, including in the back? A little. Is that thumbs up, or is that that you're good, or you want it even louder? Okay, even louder. Very good. They'll adjust it. I'm starting to hear myself, so that's probably good. Very good. Excellent. Excellent. Welcome and good evening. My name's Glenn Googans. As a lot of you know, I'm the city attorney here in City of Santa Clara as of March 1st. And I'm honored to have been deputized by the mayor to convene this special meeting of the City Council so that I can present to you a training session on California open meeting and ethics laws in compliance with State Law AB 1234. And we'll talk about more of that in a minute. I want to note for the record that we have a quorum of the council present at this special meeting with a couple members absent. I know Member Chahal is traveling abroad. Member Watanabe had a conflict with another public meeting she's attending tonight, and the mayor, I believe, as well, although hoping to be here. All have expressed a keen interest in this topic, and I offered to them my willingness to tutor them in private sessions of equal duration as this, and they all seemed very interested. That last part is not true, but I know they're interested in the topic itself. All council members, I believe, actually are in full compliance already with AB 1234. They've taken their online training, and so appreciate their interest in being here regardless of that. I want to welcome you a little bit further and give you kind of the lay of the land of what tonight's going to look like. First of all, what a great turnout. Really appreciate the interest in this. Whatever motivated you to attend tonight, whether it was the AB 1234 certificate, whether it was the subject itself, whether it was the food that I promised at the intermission. I don't think it was listening to me for 3 hours that attracted too many people here, 3+ maybe. And I imagine there might be other more enjoyable things going on tonight. I'm very grateful 49ers aren't playing Thursday night football tonight because there would be crickets, in here, I have a feeling. But while there may be other enjoyable things going on, there's really not too many things, in my view, more important for public officials and for people engaged in public discourse in understanding the rules that apply to how public officials conduct themselves and to get not only a sense of that, but hopefully a sense of how you might incorporate that, and how you conduct yourselves, all of you, in your engagement with this entity. I think that's more important now than ever at every level of government, waning levels of trust in government. And so your being here, for me, says a lot about your appreciation of the subject and your commitment to that concept. I know this has been an intense time in this city's history. I know that there are some significant divisions and disagreements amongst council members, amongst the community, and I'm hoping in a small way, maybe naive way, that talking about these subjects all together and getting training on that and a common understanding of grounding on that may chip away at that a little bit. So here's hoping that. I want to talk about a little bit more what tonight is and what it isn't, going to be. What it isn't going to be. I want to make clear I am not here to defend anybody's conduct or to condemn anybody's conduct. And if that's what you came here to hear or present, you're going to be disappointed because that's not what tonight is about. Instead, I'm here to provide information, training, hopefully in a clear and useful way that you can both understand better than perhaps a lot of you do already, and a lot of you I know are taking a lot of these trainings and maybe are experts yourself. I might draft you into presenting at a future presentation. But to really kind of take this information in and again make it useful to you in how you conduct yourself. The presentation is going to include some discussion of the Santa Clara Code of Ethics and Values. I know there's a lot of work put into that, and there's some really good material there. But really the focus is going to be on the subjects that are the state law requirements under AB 1234, because a lot of you are seeking those certificates, and that's really the orientation of this. So, training basics. We're going to be here for a while. There's just a lot of material, and we're going to do the best we can to go through it, but there's a lot. So I appreciate your patience, and hanging in there, with us. We will have a 15-minute intermission. We've got a lot of tables set up so that at intermission, we've got pizza and beer in the lobby there. There's no beer, but there's pizza, there's drinks, there's cookies. And with the way the tables are set up, we're hoping you can get your food and be back in here so that it's going to be no more than the 15-minute break, because I'm going to start after 15 minutes. This is not like the online version that a lot of you have taken, this training. We're going to have some interactive moments. We're going to have a lot more practice tips. We're going to pepper throughout the presentation particular local laws above and beyond the state law that you need to be aware of that apply to you. And so we hope it's going to be more useful, even if it's longer, than what the online training is. We're also going to have a little bit of fun sprinkled throughout and maybe some prizes at the end. We'll see how all of you do. But I'm hoping you'll enjoy at least parts of it. Some slides I'll recognize are a little heavy on words. It's not the classic don't put too much on the slide type of presentation. And one of the reasons for that is, and you've all got a copy of that, I really wanted that to be a resource for you, not just a presentation material, but something that you can actually refer to, and be useful as part of your engagement with this subject. And then questions. We're probably not going to have time for that. There's a lot of people here, there's a lot of material, but I promise you, I will stay here as late as anyone's willing to stay here to field your questions. You can email me questions that you have. I'll respond to you. If your questions are good ones that kind of implicate issues that I want everyone to be aware of, we're going to include that in the FAQs that we're ultimately going to produce along with this presentation and this tape that will be available on the city's website. So hopefully we'll get a chance to answer some, but if not, at least you've got that. What is AB 1234 and why should anyone care about it? I've mentioned it a couple times. It's a state law. It went into effect back in 2006. Among other things, it requires for elected officials and for appointed officials, boards and commission members, and I know there's a lot of you here tonight, who have a potential for receiving reimbursement of costs that you might have, although I don't think we do very much of that, but the potential is there. And so you are obligated to take this training within a year of you being elected or appointed, and then every 2 years thereafter. So I think we've actually got 25, 30 folks that are getting their certificates tonight. Glad we could provide that service. At least you'll get that, out of this evening. So maybe 1234 housekeeping. You need to be signed in order to get your certificate. You do need to be physically present throughout the training, and you will receive your certificate in the end. Everybody set on what we're doing tonight? All right. Let's talk about the subjects we're going to talk about, and then we're going to dive right into them. These are all the different elements that are required for AB 1234 training. I think they're also actually, not coincidentally, very useful things for people like you to know. We're going to talk about ethics principles, including some of the local rules and efforts, conflict of interest laws, perquisites and temptations of office. Perquisites, right? Perks, right? It's a fancy word for perks of what most of us know. Then we're going to take our break. We're going to talk about government transparency laws, fair process laws, and then closing remarks, maybe awards, and some final observations and public input to the extent people are interested. So I am lucky to be joined tonight by Assistant City Attorney Elizabeth Liz Klotz. This is both good because she knows her stuff and is one of my in-house experts on this, and you don't have to listen to me the entire time. So Liz, appreciate you volunteering, not really, to do this with me. Okay, let's dive in. Ethics principles. Lawyers love to define things first, and that's a natural thing for us to do because a lot of the rules, right, have definitions, in them, so you can figure out how to apply those rules. And ethics has some definitions too to it. It's from the Greek word ethos, meaning character. This is definitely something that Aristotle, Socrates, Plato, and other ancient philosophers kicked around when they were musing on truth and goodness. Ethos, kind of a core concept of what it means to be good and true. It's now commonly understood to mean the beliefs or ideals that characterize a community, a nation, or an ideology. And it's interesting, right? Because different cultures and nations have very different standards of ethics, right? What matters and what doesn't in relationship to everything else. And we have our own standards for that here in the United States and in California and in Santa Clara. For our purposes, really, what the practical meaning of it is, it's the laws and guiding principles that govern and encourage good conduct by public officials and employees. If I were to boil it all down into one thing, it's the concept of putting service above self. Are there any Rotarians here? I'm afraid I'm belying my Rotary prejudice. That's a Rotarian concept, and I think it's a really good one. There are, a Rotarian. There are some challenges with ethics that we're all really aware of, and I want to lay them out here because they're meaningful to think about. There's a public perception about ethics when you get into government, and this cartoon, I think, illustrates it very well. You're going into a career in politics, and there's an ethics garbage can next to you, right? You're putting your ethics in the garbage can when you're going into politics. That is a very common perception, and it is unfortunately, there's more than enough stories to fuel people's sense that really goes on, and so, as a public official, you have to recognize, in a person engaged in government, you're not going to get the benefit of the doubt from folks. Whether you deserve it or not, you're just not going to get it. There's too many stories out there about conduct that you're going to be tagged with. Another principle that's a challenging one is just human nature. I love this Russian proverb. I've included it in my presentation for a long time. The church is close, but the road is icy. The tavern is far, but I will walk carefully. Ethics can be relative. Everyone puts their self at the center of a lot of these kind of conundrums. And we all tend to rationalize things, right, in ways that make sense, for us. It's human nature. Ethics really asks you, particularly for public officials, to go beyond that, right, to not think about the self, overcome human nature, to be selfish and self-interested, and act instead in the public good. Oops, I've got one more slide out of here. It got out of order, and I apologize. There might be a couple of slides in your packet that are out of order as well. Just a couple here and there. We had some issues with the printing versus what's here. But another ethic challenge is the world's complicated, right? Sometimes what it means to do the right thing isn't obvious. Sometimes it is, but sometimes it's not. And there's a lot of rules, as you will hear, that are not always easy to understand or to apply to any particular given situation. And yet, again, that's not an excuse, right? You need to understand these rules. You need to navigate these things in order to meet the expectations that our community has for us. I'm going to now go back, and we're going to talk about Santa Clara's Code of Ethics and Values. As a lot of you know, I've been around here for a long time, and a lot of people in Santa Clara have been around Santa Clara for a long time. This has been something that there's been some resources committed to. Back in 2000, I think the effort really began on that. And the Code of Ethics and Values that came out of that says, in its own words, that it's designed to provide clear, positive statements of ethical behaviors reflecting the core values of the community. It's got broad application, applies to the mayor, the city council, all boards and commission members, all volunteers, and city staff. And it's really more guiding principles than it is a formal set of rules. And that's not me criticizing it. Like a lot of ethics standards are that. But it's not a rule, a hard and fast rule that if you violate, something will happen to you. It's different than that. And its guiding principles are broken down into 8 concepts. All of these people that it applies to are expected to be ethical, loaded word, right? Professional, service-oriented, fiscally responsible, organized, communicative, collaborative, and progressive. I'm going to remember these things in my one-year review so that I can, tie my conduct, hopefully, to our cores and values. And it's got some really good kind of elaborative materials that talk about all the different things that constitute ethical behavior. I'm not going to go into too much detail with it. I want you to be trustworthy, truthful, impartial, fair, give equal opportunities to folks, respect for persons and confidential information. Don't use your title, right, to give you advantage. Really good information there. And it also has, and I think this is pretty neat, it has the values that are put into practice. It gives examples of all these different things, of what it means to be professional and service-oriented and so on, with the list of them. And there's additional materials that flesh that out. Oops. Not just the Code of Ethics and Values, but behavioral standards for a Code of Ethics and Values, both for the City Council and for boards and commissions. There's a pocket card that kind of boils it all down into one sheet. There's some additional information there too, but this is the one that is most interesting to me. Again, and it's got kind of a breakdown of all these different concepts and the attributes and what that behavior looks like and potentially what that behavior doesn't look like. Again, we could spend a lot of time on it. There's so much else I need to go over with you, so we're not going to be able to. But you can find all of this, and there's the link, there on the city's website. And I would encourage you all to look at it. So my takeaway, the practice tips for this, are really kind of practice tips built into this as well. So if any of you are aware of this, because I hear people talking about it a lot, but haven't looked at it for a while, review this Code of Ethics and Value documents. Think about how to incorporate those principles into your day-to-day conduct as a public servant. And again, always put the public's interest above your own. That's really what a lot of these things kind of boil down to. This next slide is the fun kind of punctuations of things. There's some heavy material here. But I want you to, I think all of you got your quiz sheet when you came in, and all of you got a pen. What this is one of 10 questions that are going to be posed throughout the evening for you. Each is going to be a lawyer movie quote. I've started you off pretty easy. This obviously is an ethics course, so if you were to look this up on your phone, that would be bad. I'm going to tell you right now that you should not do that. You shouldn't share your answers with anybody. You shouldn't look at somebody else's, answer. You're in an ethics training, for God's sakes. So answer this question yourself. I've started you off pretty easy. Witness says, you want answers? Lawyer says, I want the truth. The witness says, you can't handle the truth. It's a movie from 1992. Tell me what movie it is. Okay, write it down. Don't tell me. Write it down on your sheet, and we're gonna gather all the answers at the end. If you get that right, it's worth 2 points. If you can tell me any of the lead actors' names, that's 1 point apiece. Okay? And I'm not going to give you if you name all sorts of different, the main actors, of it. Maybe I'll give you 3 on this one. So write your answer down. Try to get your bonus points. We'll tally this at the end. You're obviously on your own kind of recognizance here, so I'm expecting everybody to be fair in an ethics presentation. So that's our opening. I'm going to turn over this next segment to Liz, and we'll be back and forth. Thanks.
Hi, everybody. Can you hear me? Yeah? Okay. All right. In this next section, we will be reviewing the conflict of interest regulations that apply to public officials. These laws are important in fostering the public's trust and confidence in government. To help accomplish these goals, the laws exist to aid public officials in avoiding conflicts between the officials' public duties and the officials' personal interests. Starting with the Political Reform Act, state law was adopted in 1974 after Watergate. The act itself is found in the government code. Additional supplemental regulations are promulgated by the FPPC. And basically, officials shouldn't perform duties solely in the they should perform their duties solely in the public's interest and not further their own personal interest. The general rule is that a public official shall not participate in making, or attempt to influence a governmental decision in which they or their immediate family member have a financial interest. We're going to go into each element in the subsequent slides of this general rule. If there is a disqualifying conflict, recusal is required. There's also disclosure requirements of financial interest under the Political Reform Act. They will be discussed later in the transparency section of the presentation. So who is a public official? The government code provides that a public official is every member, officer, employee, and certain consultants of a state or local agency. But what does it mean to have a role in a governmental decision? And we're going to go over making, participating, and making, and attempting to influence. Making is authorizing, directing, voting on, or committing the agency to a certain decision. Some examples of this would be if the city manager or the city council are approving a contract, or approving a project entitlement, or city staff if they're issuing a permit on behalf of the city. That would be making a governmental decision. Participate in making is providing information, opinions, recommendations for the purpose of affecting or influencing a decision. We see this a lot with our staff and consultants, staff who are drafting contracts, negotiating contracts, or making recommendations to the decision-making party on the decisions that are going to be made on behalf of the city. Am I reading too much? Attempting to influence. This is when one public official contacts any official in the agency for the purpose of affecting a decision or contacting a decision in which you may have a financial interest.
And if I could just emphasize one point here, that's a good outline of it. But one thing I want to emphasize for folks is a lot of people think of this conflict of interest and recusal concept as just in making a decision. It's a lot more than that, right? It's really on anything that makes its way up to the decision-making body. So as an employee, as a board or commission member, as a council member, you need to be alert to your potential conflict of interest early on, and you're not supposed to be participating or influencing or commenting on that as part of your role. So be aware early on. I know how we see it as a recusal thing, but it's more than that. It's all of these things too.
So the next part of that general rule is to identify what a financial interest is. The Political Reform Act defines financial interest to include the following: business entity. So if you have a $2,000 or more interest in the business entity, or you hold a management position with that entity. If you have real property ownership interests of $2,000 or more, or live within 500 feet, there's other rules for other distances. We'll kind of go into that later in the presentation. Source of income, source of gifts, personal financial effects. This is if a decision could affect your personal income, expenses, assets, or liabilities of you or your immediate family member. And then campaign contributions. Now, this is a new law that went into effect January 1 of this year, and it now applies to council members on campaign contributions in excess of $250 within the 12 months. We have a couple slides coming up on this, so we'll go into further detail then. Okay, so now that you understand the definition, the FPPC actually has a 4-part test that they utilize to conduct a conflict analysis. The first part of the test is to identify whether or not it's reasonably foreseeable that the financial or that the decision will have a financial effect on the public official's financial interest. Now, reasonably foreseeable is realistically possible. So it doesn't have to be an actual financial interest. Is it possible that the financial interest could be impacted? If no, then there is no conflict. If yes, we need to proceed to the next step. The next step is to identify whether it will reasonably foreseeable financial effect will be material. Now, material is that threshold dollar amount, or if it's property, if it's within that certain distance of the 500-foot rule. So if it is material, then we would need to move on to the next part of the analysis. And that is, can the public official demonstrate that the material financial effect on the public official's financial interest is indistinguishable from the public generally? So this is the public generally rule. There are new rules under this, and it can be very complicated to calculate because we have to calculate whether or not the effects of 25% of the properties, businesses, or individuals of the jurisdiction has no unique effect on the public official. Because of this, it's very difficult to apply, and we typically would recommend getting an FPPC opinion to confirm its application is advisable. If it is considered a conflict, or if the answer is yes, sorry, to that it is not, it doesn't fall within the public generally exception, then we look to see whether or not an exception can apply. There are exceptions for rules of necessity, whether it's legally required to vote, and there's no alternative exists to allow this to move forward. Also, a council member or a public official who is unable to participate may participate as a member of the public on an item in which they have a personal interest. So here are some practice tips. First, you want to know your financial interests. Before you're working on a project or an item on the agenda comes forward, you want to be able to identify whether or not you have a financial interest on the agenda. Next, ask whether or not the decision that you're about to make impacts your financial interest. If a conflict exists, do not participate in or discuss or even influence that decision. Disclose your basis for recusal and leave the room. When in doubt, seek legal advice and consider recusal.
And before we do this next question, I just want to make a little point about that. Our office, of course, in our representation of the city, wants to be helpful with people in sorting out their conflict of interest. If, in fact, you have a conflict of interest and the city acts, that decision can be challenged because it wasn't lawfully approved, right? Because people participated in it where there's a conflict. But as it relates to your situation, personally, you're really kind of on, you're responsible for your own business. We will provide you information, we'll steer you to the right information, but ultimately you're responsible for identifying and making these decisions regarding these conflicts. As an individual, you're not our client. The city is our client. So we're going to be helpful, city clerk's going to be helpful, my staff, will be, but if there's any uncertainty, our typical advice is recuse. If it's a close call and you really do want to participate, hopefully we'll be able to find out in time for us to be able to assist you in soliciting kind of an opinion from the FPPC. So that's how we approach these things. We're always helpful and want to steer you the right direction. And so when in doubt, seek legal advice, either from us or your own independent counsel. Thanks.
All right, so here's movie quote number 2 for everyone to complete. Mr. Hart, here is a dime. Take it. Call your mother and tell her there is serious doubt about you ever becoming a lawyer. 1973.
Okay, the movie. Couple main actors in this. 2 points for the movie, 1 point for any actor that you're able to name. I don't see a lot of pens scratching. Are these hard? Is this just lawyer geekiness? Yes, it is. Not the first one, though. Not the first one.
I will say this is a movie they recommend watching before you go to law school.
Or you go to law school.
Yeah.
A little bit of another clue with it. It also became a television series. Doesn't sound like that's going to be helpful. But.
Oh. Okay.
What's that? Oh, all right. We'll keep going.
All right, so now we're going to talk about contractual conflicts of interest, also known as potential 1090 violations. This principle under Government Code 1090 prohibits self-dealing in government contracts. The general rule is that a public official cannot make or participate in making a contract in which they have a financial interest. The consequences of this is that a public official has a financial interest, makes the contract void, and penalties also apply. Participation could also be a criminal offense and also require resignation of the official. So how is 1090 applied? It applies to officials, members and officers, employees, and sometimes consultants. When Government Code 1090 applies to a legislative body, the entire body is precluded from participating in that contract unless an exception applies. Employees, however, and advisory body members, they can abstain and recuse, and that's usually sufficient for a contract to move forward. However, it's the final approval authority of that legislative body that kind of prohibits the city from being able to make that contract if there is a conflict. So 1090 applies to all types of contracts. We're thinking construction, purchasing, development agreements, grants, and even donations. The making of contracts includes negotiations, discussions, planning, reasoning, and the give and take that goes beforehand when making in the making of the decision to commit this on behalf of the city. Financial interest is also broadly defined. It can be a direct, indirect, positive, or even a negative effect on your financial interest. Would potentially preclude you from participating. Exception for the remote interest is in certain cases. The remote interest, you would need to disclose that remote interest and then recuse yourself from participating or even attempting to influence any part of that decision-making process. Oh, and then there's a limited rule, as we discussed, the rule of necessity. And if council has a duty to act on a matter, it may do so despite of a conflict if the council is the only entity capable of acting on that matter. So for contractual conflict of interest, ask yourself whether or not you will personally gain from any contract you're working on or being asked to approve. If personal gain is possible, seek legal advice early, because this can be a really tricky area. All right, so now we're going to talk about the Levine Act rule. Prior to January 1, 2023, campaign contributions were not treated as financial interests for elected officials. Now, council members and commissioners are prohibited from participating in decisions if receiving a campaign contribution from a party or a participant to the decision in excess of $250 within the prior 12 months. They are also prohibited from accepting campaign contributions from the party or participant in excess of $250 for 12 months following the decision. Please keep in mind, though, that this will apply prospectively. The 2022 campaign contributions do not apply. There was some decision and just now a recent AG opinion basically saying this is going on a prospective basis, so the prior campaign contributions from 2022 will not apply. But however, we will be issuing a memo prior to our campaign season for 2024 to kind of remind everyone about the Levine Act and the requirements under there.
So another point of emphasis here, this is going to be super challenging for every jurisdiction to sort out. This rule used to apply, but only to planning commissioners, right?
Yes.
That were running for office. And previously, campaign contributions were expressly excluded as financial interests for city council members and other elected officials. This rule makes sense. It's just the way it's drafted. It's going to be really difficult to figure out. So that's our job, to figure it all out and to apprise you of the risks and hopefully develop some protocols and standards to help kind of manage that. So more to come on that.
Oh, and I guess I should just say, if there is a campaign contribution and then you've identified it, you can return that contribution if there's an issue. If you can't return that contribution, then you'll need to disclose and recuse yourself from participating on the matter. All right, so some practice tips on this. You want to review the agenda for potential conflicts that might arise from campaign contributions, but you also need to be very vigilant during the meeting as well for participants who have a financial interest and advocate for or against a decision. So a member of the public could come and can be considered a participant if they're advocating and they we're also a campaign contributor of yours. So that's something that we need to be able to track and monitor. We just, if you have any questions, seek legal advice. This is a really new area. We're going to be trying to figure out how to apply it as we go. All right. So here are a few slides on, or just one slide actually, on conflicts when leaving office. There's a government code section that applies to elected officials and the city manager for a period of 1 year after leaving office that prohibits them from being able to represent an entity and appear before the city on any administrative or legislative action. So it's a 1 year prohibition from lobbying the city after leaving office. The city has its own city code that applies to city officials, boards and commissions, and designated city employees with a very similar 1 year prohibition from lobbying. Also in the government code, there is a prohibition from public officials from making or participating in making or using their official position to influence a governmental decision with any party in which they are seeking employment. So if they're negotiating or arranging prospective employment, they should not be participating in any decision, governmental decision with the city. So just some practice tips. Be aware that after leaving office, you won't be able to lobby the city for about a year. And when participating in any city business or decision, you should not be seeking future employment or employment relationship with that party.
Okay, a lot of information. I hope you were listening because we're now going to test your knowledge. I used to do really elaborate, dastardly long, nuanced fact scenarios, like for a law school class, and I'd have like 5 questions after it. And I'd hand it out ahead of time, but it still wasn't enough. It was too hard. So this, hopefully it's not too simple for some of you who are experts in this. It's intended to be little bite-sized morsels of some fact scenarios for you to think about. When you came in, you were handed a green and a red card. I'm going to try to phrase these questions in a way so that I can test what people's views are about the right answer, to this. I've been to one where people handed out a yellow card, but the lawyer always put the yellow card up, right? Because you could always argue both ways. So I didn't give anybody a yellow card. But if you want to put up both because you want to argue it either way, put up both. Although I warn you, I will probably call on you if you put up both for having you to help do the work for us, right? To explain, all sides of it. So Liz is going to help me with this because she's really sharp on these rules. But your first question here is, there's a planning commissioner, kind of torn, and she's scheduled to vote on a development project on a property owned by her sister. Can the planning commissioner, based on what you've learned so far or other things you might know, vote on the decision to approve the development? Can the planning commissioner vote on the decision to approve the development? Okay? I want a green for yes, and I want a red for no. This is great. There's a split. A lot of reds over here, and some greens kind of here and there from some of the sophisticates. Okay? So can she vote on it? Who voted yes wants to speak to why she can vote? Member Jane. Yeah, I think actually, unless Liz is going to correct me, I think that's the better answer. If it were a closer family member, right, there might be some other issues. That if it was a dependent sister, right, that may be an issue. So the better answer here is she could always choose not to participate, but under state law, right, there's not a financial interest and she does not have to participate. One for you. Okay, what if the Planning Commission's member's sister, her name is Ima Mooch, had been living with her, Planning Commission's sister, rent-free up until 6 months prior to the vote? Okay, does that change anyone's answer? We had a lot of reds already, so I assume the reds are staying red. I see reds everywhere. Is there a brave green anywhere who wants to speak? I see, is that a green? There's a red here. Do you have a green? Do you want to argue the? Yeah, I want to hear.
Well, I was just thinking financially, she's not getting any money. Yeah, she's already rent free.
So the fact that it's rent free, that is a potential financial interest, right? Or it's a potential relationship that's more than a mere sibling, because in effect she's providing her some sort of benefit. So in effect, her sister's a dependent. But Liz, does it create a financial conflict?
Yes. Yeah, because it doesn't matter if it could be a negative or a positive financial impact. So,
Well, what about the fact that it was 6 months ago and it's gone already?
well, within the last 12 months.
So,
Yeah.
okay, so see, some of this stuff's not as easy as you think. Nancy.
Okay, so the first question, what if kind of torn is in her sister's will or trust as inheriting anything?
Ah, very good. Potential financial interest. Liz, do we know the answer
There's
to
a
that?
potential financial interest.
She's in, so kind of torn is in her sister's will to get a bunch of stuff when her sister dies.
I don't believe it does. It doesn't create a financial.
I think inheritances are exempt.
Exempt,
We'll
yeah.
look at
Yeah,
that.
but I'm pretty sure inheritance.
We'll look at that. I think inheritances is an exempt interest. But there's a great question, okay? It's a great question. Okay, are we ready for the next one? Yes, quickly though.
Isn't there a simpler rule? If it raises concern and conflict of interest, why not simply bow out on the possibility that others might object?
That is a great point, and we're going to talk about appearance of impropriety throughout this. Right now, though, we're interpreting the rules, okay? So that's a great, excellent point. Hold that thought, and we're going to even talk about it here in some of these scenarios, as you will see. Okay, next scenario. City is considering building a park on city property across the street from a council member's home. Can the council member vote on the decision to build the park? Okay, can the council member vote on the decision to build the park? I see a green. I feel red that this is a problem. Is there a green out there, or a double green? Or a double green and red that wants to speak to why maybe? Yes. Aren't you smart? That's the right question. So you held up both, right? Because you needed more information. I think a lot of the people who held up the red thought, given the standard size of streets, that distance wasn't really going to be an issue and that it was plenty close enough. But distance is exactly the right question. And you'll see in the follow-up too, what if the park was 800 feet away from council member's backyard? All right? Can that person participate now? I see some greens, but I still see some reds. Why is red the better position? Remember, Jane, you're a ringer. I'm not going to ask you. Remember, Becker. 1,000 feet, that's right. So there's two. It used to be a 500 feet standard. It is now a more complicated standard, right? And Liz will correct me if I'm not describing it correctly. 500 feet or less, you're deemed to have a financial interest if the project is, significant enough and has a potential impact. From 500 to 1,000, you can demonstrate that it won't have a financial interest, but the burden, I believe, is on you to demonstrate that it doesn't. It's only over 1,000 feet where it's not presumed to have a financial interest on. Yes?
Now, you actually just answered what I was going to say is, what was there before? Is it an improvement, is it a reduction, or is it just still the same?
Another good question, but the fact that, and that's a great question, right? Because there are certain things that might happen near you that aren't a big enough deal, right, to have a financial interest. I think the thought is, we're building a new park, right? Building a new park, right, is an enhancement, a significant enhancement to a neighborhood, and that would probably be viewed as a good thing or a bad thing, right, in a meaningful enough way that it would be likely to be a conflict. There is an exemption for small improvements, right, and I've advised any number of different people on that. If it's just a minor improvement to existing infrastructure and it's 50 feet from your house, it's a minor improvement to existing infrastructure. It's not going to have a financial interest.
Well, take, for example, what if it was already a private park that's currently being made public, that already had public access to it,
Those are nuanced fact scenarios, and they're very good things to think about. Nance?
Okay, it may not quite fit with this one, but is that 800 feet away by Google, or is it 800 feet away by Google?
Yeah, great question. The way that the lines are drawn is you draw from the point of where you're at, you draw a circle, and what do we use? What is our system that we use?
We have our own GIS.
We have our own GIS system, so it's according to our system, which is pretty accurate. Yeah, it's pretty accurate. Right, it's not driving there. Right, it's as the crow flies. Absolutely, I'm sorry. Your Google was, yeah, I thought you meant like maps. No, it's not by maps. It's as the crow flies. Yep, very good. Okay, next one. City Council is voting on a contract to install solar panels on city facilities. A council member who co-owns the solar company recuses herself from participating or voting to approve the contract, and the contract is awarded. Is that contract valid? Did everybody hear the scenario? You've got it on your sheet too. Is the contract valid? Green. I see greens. Is there a red anywhere? Red back there, and a red here. Remember, Hardy, I'll get you later. I want to go to the back. Why? Yes.
Actually, though, it's not that they have to recuse. They cannot enter into the contract.
They cannot enter into the contract.
Yeah.
Isn't that interesting? 1090 is a heck of a rule, right? If there is this relationship, that contract cannot be entered into. Okay, so some of this stuff is very severe. Under 1090 is different than your standard conflict of interest rules. There is a rule that if the interest is de minimis, right, under this very nuanced thing I'm not going to teach you tonight, that the person actually can recuse themselves, but in most circumstances, if there is an interest in the contract, the contract's void, all right? Let's keep it. We can talk about a lot of these. There's a lot of nuances to these, but, oh, there's one more. Okay, this was one of my old lawyers making fun of me. So I kept it in there. Ben Boogans served as city attorney for the city of Cohiba from June 2018 to July 2022. In September 2023, a cigar owner asks Ben to represent the business in its tobacco license revocation hearing before the city's hearing officer. Can Mr. Boogans represent the cigar store owner? Can Mr. Boogans, not me, represent the owner? Answer? Yes or no? Green for yes, red for no. The yeses are right from a legal standpoint. But, sir, should the person do that? My appearance of impropriety person in the back there. Oh, okay. No, but I think your math was right. You said but if you said green, you were right, right? Because it's more than a year. But should Ben Boogans do this? He's a lawyer. This doesn't look good, right? It's an interest where you were advising, in the first place. Sure, the year has passed. Can't you do something different? Right? So I'm not going to tell that person that what they did was unlawful, but it's definitely the kind of thing you want to think about as a public official. So we're through our scenarios, and we've got, I think, our next question. Okay. All right, here's the quote. Oh, sweetheart, you don't need law school. Law school is for people who are boring and ugly and serious. And you, Button, are none of these things. The movie's from 2001. It's a charming movie. I see some people writing this one down. I think some people are going to get this one. Am I still up?
Yeah, you have perks.
Okay, can I give you that? Okay. The next large category that we're in, we're doing pretty good on time. We need to hustle a little bit here. Our perquisites and temptations of office. We're going to talk about all those miscellaneous things that are required for AB 1234. And the first one is gifts, gift limits and disclosure. There are substantial provisions in the government code regulating gifts to public officials, right? Like there should be. The applicable code sections start at Government Code Section 89503. There's a bunch of sections after that. Et sec means a bunch of sections after that in Latin. And there's an extensive set of regulations that interpret these code sections, starting in the 18,000s and for a bunch of pages after that. And in general, the central rule is while the receipt of gifts by public officials is not prohibited outright, state law imposes limitations on those gifts and disclosure requirements. The purpose, of course, is to discourage undue influence on public officials due to the receipt of gifts. The idea being that, right, a little gift is probably not going to cause you to do anything you wouldn't do otherwise, but a big gift might. And so there's rules that are set up about that. Definitions, as usual, for lawyers. What is a gift? A gift is any payment or other benefit provided to an official that confers a personal benefit for which that official does not provide goods or services or greater value, right? If you're paying somebody to do something, that's not a gift. But if you're giving somebody for nothing in exchange, that's a gift that needs to be treated as such. It would include a rebate or a discount in the price of anything, right? It doesn't need to be an actual thing you're given, but value that you receive. Unless it's a rebate or discount that's given in the normal course of business, right? If everybody's getting this rebate or discount and you just happen to get it too, it's not a gift. It's kind of like the general, purpose application rule, an equivalent of that. So that's what a gift is. The value limits on gifts. There's a limit on the value of the gifts that you can receive from any one source. And the current limit is $590. And the limit applies in any 12-month period. It's a rolling 12-month period, right? It's rolling. It's not calendar. It's a rolling period. Any rolling 12-month period. If you accept gifts in excess of $590 from any one source during any 12-month rolling period, you've got a problem. You violated the Political Reform Act, and you're subject to civil and criminal penalties, depending upon how intentional you were, how big the gift was, and the implications that it might have around you. And FPPC and the AGs have issued and taken action on these. You're also, although this seems beside the point, deemed to have a disqualifying economic interest in any matter involving the gift giver, and you may not participate in that matter. The more serious thing is that you violated the law, but you also can't participate, in any decision if you've exceeded that limit. Disclosure requirements. If you are a designated public official, state law requires you to keep track of and disclose in an annual report gifts you have received in your capacity as that public official. Form 700 filers, you're familiar with this. There's a gift exhibit on that. And a designated official, public official, is defined as local elected officers or candidates, and employees designated in the Conflict of Interest Code. Interesting that it's candidates, too, right? Candidate is a very broad definition of a public official, and this applies, in that instance. The designated public officials must report the gifts, as we've talked about, on a Form 700, and the gift disclosure requirement is anything of value of $50 or more, all right? You can't go over $590, but if it's more than $50, you need to disclose it. Every one. One handy thing for people, I don't think a lot of people are getting gifts, and we'll talk about you probably shouldn't be, right, in general. The FPPC has a gift tracking app that filers can use. So if you are in the normal course of things interacting in ways where you get gifts and you want to keep track of it and disclose it, there's actually an app. There's an app for that, to help you with that issue. Very quick. That's a great question. And it would be and I don't know the exact set of rules for it, but it would be a reasonable person's determination of value, right? So if something, you've given something and on Amazon you can get it for a certain amount of money, it would probably be the average price that would be in the marketplace. And it probably depends on the nature of the item. Liz, do you have any details on that?
Yeah, I mean, yeah, normally it's the fair market value.
Fair market value. So it's a kind of a fair market value concept. And I will tell you, if you're in this world and you're disclosing stuff, you shouldn't be cute about it, right? Don't be cute about it. If it's something that costs $600, but you found some place that you could get it for $480, that's not good.
Really about the person's value of the gift. If you gave somebody a $10 gold coin, that's face value is $10, but collector's value is $1,000.
No, that's absolutely right. Yeah, it's not face value. It's what its fair market value is. Yeah, it's not its face value. That's right. It's what its true value is. That's right. So, gift exceptions. There are things that aren't gifts. Gifts that are returned or donated, or reimbursed within 30 days. You can say, hey, I didn't realize I got this gift. I'm going to give it back, and no longer becomes a gift. But if you're going to donate it, there are rules about how you would donate it. You've got to donate it to a 501c3. One of your family members can't have a position with that 501c3, and you scoundrel, you can't donate it and take a tax exemption for it. Right? That's, in effect, you deriving value from the gift. So if you're going to donate it, if you get something and you're going to donate it, you got to donate it, and not get any benefit. Gifts from family members or inheritances, as we talked about, are not gifts anyway. Admission paid if you're making a speech somewhere and you're paid admission. A bunch of other different things that are here that are excluded as gifts. One that's an interesting one that comes up from time to time. If you get tickets to a political or a 501c3 fundraiser for something, it's not a gift, but it's only not a gift if it's the organization that gave you those tickets. If anyone gets hosted to something by somebody else, right? Developer buys a table, right, at an event, and they invite you on that. And it's a 501c3, and it's a good charitable thing, and you want to go. Go. But you got a gift, right? The organization itself did not invite you. Personalized plaques and trophies, campaign contributions, we already talked about that. And there's special rules that apply. So, there are also an unusual couple of things that, and there's more than this, that are not actually subject to the $590 limit. One of them is wedding gifts, and I looked up to try to get an understanding of it, and it just says wedding gifts. There's no explanation at all. Maybe there's a reg somewhere that I didn't see that explains that, but if you get a really nice wedding gift from somebody, apparently the $590 limit doesn't apply. Some gifts that are unusual, transportation gifts, are also not subject to the limit. Not that important for this group. We had to teach it to you, but we're going to talk about travel rules that apply to travel gifts, later on, because there are some things that you need to think about. Okay, practice tips on gifts. It applies to all city employees, not just elected or appointed officials. So everyone, a lot of city employees here. Thank you guys for showing up. You weren't obligated to come, but you did because you're interested. This rule applies to you as well. Acceptance of gifts and favors in the course of or related to an individual's employment with the city is strongly discouraged, not encouraged. Strongly discouraged. Let me be clear about that. It's discouraged, right? And it's discouraged by the law too, right? It's not that kind of thing that anyone should be trading on. And in Santa Clara, this rule is a little strict, but maybe rightfully so, appropriately so. No employee is supposed to accept a gift in excess of $20 or more in value from anyone's source during the calendar year. Santa Clara says to its employees, this is not something that you should be engaged in. Some little minor thing, if someone buys you Coke or something, is okay, but $20 or more is actually the limit, the local rule, in Santa Clara, and I think that's meaningful. So, more to say that, but we want to keep going. And here's your next quote. I hate lawyers. I just work for them. Movie was made in 2000. Very good movie. People know this? Are there people who know this, or do I need to give a hint? And now remember, on all of these, right? 2 points for the movie, and then points for the lead actors too, right? In any of them. So go back. If you've answered one before, I forgot to remind you on that. Okay, I'll give you a hint. In this case, it is an actress who said this. Not enough of a hint? It is an actress who is famous for playing.
Oh, yeah. I got it.
Oh, okay, that's all I needed to say. Okay, no more hint. Got to separate the wheat from the chaff here. Okay, behests, quickly. Under Government Code Section 84224, there's this concept of a behest. And a behest occurs when a person donates for charitable, government, or legislative purposes on behalf of, at the request of, an elected official, right? Sometimes elected officials are in good positions to be able to encourage people to donate to things, right? City interests and charities. Hey, so-and-so, big muckety-muck contractor, would you be willing to give $10,000 for a city event? Sure, I would. I would do that. Nothing nefarious about it, right? Necessarily. But if it's over $5,000, you have to disclose it, right? It's got to be clear who the person who solicited that was, and it needs to be public, right? It's a transparency rule. We want people to be able to solicit charitable contributions from other people, but it's got to be done publicly over a certain amount. And here's the rule for that. It's got to be done within 30 days. Honoraria. Someday someone will pay me an honorarium. Government Code Section 89502, honorarium is any payment that you might receive for a speech, article, published, or mere attendance at an event, such as a conference, or if you're invited to speak at a conference. It applies to elected officials, candidates, again, for elected office. Someone's trying to woo you. Planning commissioners, the city manager, and the city finance director. You cannot accept an honorarium. A designated employee shall also not accept an honorarium for any source if that employee was required to report the receipt of that income or gift on their Form 700. So if you are a Form 700 filer that designated to contribute a gift, you also can't accept an honorarium. There's exceptions for certain specified professions and charitable donations. Guess which profession is accepted? Attorneys, thank you. Yeah, lawyers drafted the rule. They accepted themselves. And I guess the concept is that if that's something that's typically done, right? Say Liz and I were hired to do this training by somebody else and we were paid an honorarium for that. Could we do that, Liz? Not that anyone would want us to, but could we accept an honorarium?
We could.
There's different issues with that. It might be a prohibited outside activity, and to the extent we use city resources in producing this presentation, doesn't seem right to me. So if we were paid, we would give it to the city, right, back to the general fund. But in theory, our profession could actually do that. So if you get one, you can give it back and get yourself out of trouble. So next concept, misuse or unlawful gift of public funds. This is both statutory and common law concept. Not surprising at all, right? Under state law, it is unlawful to use public resources for personal or campaign purposes, of course, right? You're not supposed to do that. It includes money, equipment, supplies, compensated staff time, use of telephones, computers, machines, right? It's really anything. There's a nominal usage, carve out, but it's any kind of public resource. If you violate this rule, you can be charged with a felony or a misdemeanor, and you can be barred from holding public office. This is a very serious violation of the public trust under state law, and serious violations of it can result in very serious consequences under the California Penal Code and the Government Code. A local rule alert, not a rule so much, but a guiding principle. This kind of whole concept is actually built into Santa Clara's code in ethics and values. So again, good to tether that and look at a lot of these things are replicated there. I think I'm turning this one back to you for mass mailings. Thanks.
So, next slide. Okay. So along the lines of the use of public funds and misuse of public funds, mass mailings are prohibited, or generally prohibited.
Bless
There
you.
are some exceptions. So the definition of mass mailing are tangible items that are delivered to a person's residence, place of business, or post office box, where that item either features an elected official or includes the name, office, photograph, or references the elected official in the mailing. Where all or part of that mailing is paid for with public funds, and more than 200 substantially similar items are sent in a single month. Please keep in mind that there is no FPPC rule for electronic communications or mass transmission, but you should still be aware that there are prohibitions for the use of public funds for campaign and political purposes, and so that's just something to be aware of.
Yeah, and another point to emphasize is, isn't that interesting, right? That's how people communicate now, electronically, and this doesn't apply to that, electronic communications. But if you remember those rules before, it would still be, if you were using it for personal purposes or campaign purposes, and there's separate rules about that, prohibitions on the use of public resources, right? So while the mass mailing rules doesn't apply to use of electronic things, if you're using any kind of thing like that, public resources for a personal or campaign purpose, a different rule would prohibit you from doing it. So just a point of emphasis. Thanks. Sorry, Liz.
As I mentioned, that there are permitted mass mailings that are identified in the government code. They include the letterhead, meeting or event announcements, press releases, public agenda items, inter and intra-agency communications, legal and regulatory notices, tax bills, checks, and similar documents. However, permitted mass mailings are prohibited 60 days before an election, and these are the ones that are actually prohibited. It's an item where the elected official's name appears in the letterhead or logo or on stationery, or an agency announcement of a meeting or an event that is sent to the elected official's constituents, or it's on official agency event where the elected official is also mentioned, and also business cards. So those are the three that you need to be aware of 60 days prior to the campaign, and city staff should also be aware of that since they do a lot of the mass mailings for the city. All right.
You could do these ones quick.
Yeah, there are also regulations related to travel, lodging, expense reimbursements. They are generally considered a gift under state law and subject to the limits and reporting requirements unless it falls within an exception. These are the exceptions: payment by another government agency or a nonprofit for travel that is related to the official duties of the public official, travel for official agency business, travel that is lawful as reported as a campaign contribution, travel where official is providing a speech or presentation. Okay, and this is another quick slide, just so that you're aware. There is a California Constitution prohibition of travel gifts from transportation companies that dates back to the early 1900s, stemming from the Pacific Railroad activities of the time. It does not prohibit employees. However, it only applies to interstate or foreign carriers, and also applies regardless if travel is for official business or even personal. A violation in this case is forfeiture of office, and I think Glenn has a story about this one.
I do. I have a story on this. This seems so obscure, right? But I was at, some years ago, a meeting amongst business and government officials in San Diego, South County EDC meeting. And one of the sponsors of that event was Southwest Airlines. Southwest Airlines, as part of their sponsorship, gave every attendee a travel voucher. Isn't this great? Southwest Airlines, travel them all the time. I'm going to get a travel voucher. Everyone went up and got their travel voucher. And I was like, there's something not right about this. I looked it up on my phone, and I knew there was a rule like this. And I was looking for all my elected officials, to tell them, and anyone I knew who was an elected official, don't take the travel voucher. So these things, again, this is one of these things. This seems like an obscure rule, but these things can pop up, right, in unusual situations. So you knowing all about even the obscure rules is good.
Okay. I think I have just a couple more slides before the break. So I'm going to cover loans. So all Form 700 filers are required to disclose loans received from other persons. One exception is that loans from commercial banks, lending institutions, and close family members do not need to be disclosed. There is also government code provisions that prohibit loans from over $250 from other city employees or parties with whom the city contracts. Those are also prohibited. Any personal loan over $500 to an elected official must be in writing and set forth some key terms. Just a practice tip, avoid loans from people or companies with city business just to avoid any potential issues. And my last slide is to cover Penal Code Section 68. This is bribery. Bribery is the act of receiving money or any other consideration in exchange for one's vote or action on a matter. It is a felony under both state and federal law. Under state law, it can result in prison time, loss of public office, and a ban on holding future office. And also can affect retirement benefits. A conviction under federal law can result in up to 15 years of prison time. Please keep in mind a gift or a contribution is a bribe if there is proof of a quid pro quo. A quid pro quo is a promise to perform or not perform an official act. So that's just to keep on your radar. And then before we go on break, just want to give you one. Oh no, do we want to do perks?
We have scenarios. I think we're going to try to do the scenarios.
We have
too.
scenarios as
yeah,
well.
we're doing okay. We'll do the scenarios too.
So here's a quick quote. Miss Jean Louise, stand up. Your father is passing. 1962.
Okay. The movie, 1962, and the lead actors. Okay? I'm going to give a bonus point for this one. This one is worth 3 points. The movie is worth 3 points. Sorry, I have to do it. The movie's worth 3 points. Okay. I know you can all smell the pizza. I'm so glad it's here. I did one of these once, and the pizza came like 45 minutes late, and the crowd turned on me. They did. The crowd turned. But I want to do these scenarios. You guys were good on the last ones, and I want to kind of crank through these, with you. Remember, you got your green and your red cards, and we'll go quick. Okay. Scenario number 1. The city contracts with an insurance carrier to provide liability insurance for the city and its employees. The insurance carrier holds an annual client appreciation day at Disneyland and reaches out to offer city's insurance manager a ticket valued at $500 for the experience. Under state law, can the insurance manager accept the ticket? Green for yes, red for no. Green for yes, red for no. I see a lot of reds. I see a few greens. Can a red tell me their reasoning? One of you's hiding behind your red card. Why do you think that's not good under state law?
Because they're contracting with the insurance.
Conflict of interest. Yeah, I don't think that it's a great point, and we'll talk about that in a minute. But they're contracting with the insurance company on behalf of the city, right? So it's not their own personal financial interest.
Well, they got a gift.
They got a gift.
They got a gift in return.
Yeah, worth $500. Are you finding quid pro quo? Is that what you're finding, quid pro quo? That's a great point. Under state law, though, under the pure gift laws, in fact, it's okay. This person can do this. You're getting at the better point, right? Just got a contract awarded. It's not a $50 nothing or a $20 something, and even that could be a question, right? In Santa Clara, $20 something is a problem. But it's a big thing in the wake of just having had a contract, finalized. How does that look out in the public? Unacceptable. I actually had a situation where a person asked me about this. It was an IT director who was saying, hey, I just got invited, by this company we just contracted with to go play golf with them, and it's at, Pebble Beach. That's like $485 or something. I'm like, don't do that. I think you lawfully can do it. Don't do it. He didn't do it, right? You just can't. The relationship, like that is just something you can't, even if you can find a way to lawfully do it. I'm going to hold the question, if you might, because I want to crank through these, and then maybe you can ask me and I'll respond. Next question. A jewelry shop makes a limited edition bejeweled Santa Clara lapel pin. Sounds like that might be something we would want. The owner reaches out to the mayor and council to offer them the first opportunity to purchase the pins at a discount. Can they purchase the item? Green says yes, they can. Red says no, they can't. Don't ask follow-up questions yet. If you want to hold up two.
He's going to hold it too.
Okay, I've got some folks that are holding up two over here. You held up two. Why did you hold up two cards?
What type of a discount are you getting? What's the monetary part of the discount? Part of the,
That's right. Remember, you're valuing the gift by the discount amount. In theory, right, a $10 discount is would be of nominal value, and it wouldn't be something that would exceed the limit. However, what other part of this bothers people? Yes. Yeah, exactly. They had a special early access, to this. They had a special early access to this, and that's the kind of thing that needs to be, factored in when you're making these decisions. Very good. If the lapel pin was of nominal value, right, and they got special access, who cares, right? They'd probably be okay. Member Park.
but it also says limited edition, so it's possible that if they sell out or something like that,
Yeah, right. So.
the fair value, market value is much higher.
And that's isn't that the right point though, right? These circumstances differ depending upon any number of things, and you need to think about those, things before you get the right answer or come to the right answer. Okay, yes, quick. I'm sorry? No, that's right. Another factor, right? It's really just something that's being, sold, right, to the public. And the issue there is what's the value of it? Is there special access to it? Give them access to something that could become super valuable, and what's the discount, right? So all those things factor. No obvious answer for this one. You kind of have to know more information. Okay, number 3. On a workday afternoon, a fire deputy learns a mountain bike he'd had his eye on is available to purchase at a local store, but only one is left and his car won't fit it. He asks the fire chief if he can help him out by picking up the bike in the chief's rarely used city-issued truck and transporting it to the deputy's home in Hayward as soon as possible. Can the fire chief do this?
Hold on a second.
I see a sea of red. I see a couple of greens. Hold on a minute, you said. Yeah.
Yeah, well, is the fire chief using his truck all the time, like to and from work and taking it home and so on? Then if he's coming on the way from work and he has the fire truck at home most of the time too, then it'll be okay to going by on the way and picking it up.
I've lured you to the dark side with that particular fact. And you fell for it. You fell for the dark side. Those are, they're reasonable things to think about, right? But kind of a rationalization.
It's giving you a ride.
Yeah.
You're walking and you're limping. And
Yeah, there might be a fact circumstance where it's just incidental, but this one really isn't, right? And that's why we tried to lure you with seldom used vehicle, right? Doesn't matter if it's a seldom used vehicle, right? It's a city resource. You can't use it. So you're right. Could be rationalizations. You're erring on the side of finding a problem. Okay. So the last one, but I'm glad you spoke up because it helps tease different nuances to it out. Okay, number 4, and then we're going to break. A council member is running for re-election. His campaign manager comes by city offices to check in and offers to send a mass campaign email with the council member's picture to constituent voters from the council member's office computer while the council member is in meetings. Is this prohibited? There's some shy people. Some people are not. I've made people shy now. They're like, wait a minute. I see a bunch of reds. I see a green. Sir, a green. Is it prohibited? Sorry. Yeah. I'm sorry. I didn't phrase the question very. Is this prohibited? So if you think it's prohibited, put up the green card. Yeah, sorry. I also tricked people into answering wrong by how I phrased the question. Okay. Green, pretty clearly yes, right? What if they were doing this after hours? Still green. Yeah, right, still prohibited. Yeah, still prohibited. See, are you going to argue with me? Okay. No, I'm just saying, everybody's hungry. So we did pretty good time with how we started a little bit late. That was really good time at 6:30. This is a break time. We might want to start maybe with the first couple of groups first. If people could just hang out, let people go in there, grab some pizza, come back, to your table. Then we'll release you, in the next, round. So if these first two groups, if you're going to grab pizza, go do it right now. There's food, there's drink out there. Grab it and then bring it right back to your tables. That's one of the reasons why we set up tables. Yeah. Okay, folks, I'm going to call us back to order. I know a few people are still getting some food, but I want to get you out of here at a reasonable period of time. So we're going to start in again. Hey, folks, if everybody can come to order, we're going to try to get started again. Maybe my mic isn't loud enough. Yeah. Up the volume, please. Very good. And then down, lower the volume in the chambers. Very good. Can folks hear me okay? Appreciate you being quick and coming back. We want to get started again, so I don't have you here too late. A couple things, though, that with questions over the break and clarifications we got, from folks that I wanted to share with you. One person asked, "Hey, does any of this affect my ability to donate, to things? I'm on a board or commission, or I'm not. Can I donate to things?" And you absolutely can donate to things. It's when you receive things, right, that it becomes an issue. So donate away. If in fact you, though, get some benefit for something, right? There are some complicated rules about raffles and prizes like that I'm not going to train you on, but just be aware of stuff. You, of course, can donate, but if you're paying for something and you get it back, just like on your taxes, right? There's some nuanced rules about that. Keep that in mind. Secondly, I wanted to point out that, because I know a lot of private industry works this way. There's all sorts of exchange of gifts and benefits and things, right, in the private market. And the numbers we're talking about here are probably chump change, right, compared to a lot of Silicon Valley, goings-ons between private companies. That's all and well and good, but when you're in the public sphere, there are different rules. So things that might be customary that you hear are customary for your friends are not customary, for public officials. So be aware that strict rules apply. The rules are statewide, and there's no special pockets of privilege for a place where maybe a lot of that kind of thing goes on. There was a question, and we're going to get into it in a minute, about if you're a contractor acting on behalf of the city as opposed to a city employee, do the rules apply to you? And they might. A lot of contractors, because of the kinds of decisions they make on behalf of the city, are treated as city employees for a lot of these rules, and they are in fact Form 700 filers. Liz is going to talk about that next. So if you're a contractor and you, in effect, have discretionary authority to act on behalf of the city, you may also have a lot of these rules apply to you. Member Jane pointed out to us that we didn't get the nuance on the rule about the public generally right. There was a rules change a couple years ago that applies to residential property owners, where, in fact, the rule has been more broadly applied to them. It affects, for residential folks, 25% or more of people similarly situated. It's only 15% or more people similarly situated. The 25% rule still applies, but that's for business property and nonprofit property. So there's some nuance to that. We'll make sure the slide gets corrected for the next time. I think that's what I wanted to talk about, and let's go to the next slide. We've got a whole other chapter for you, Article 4, Government Transparency Laws. A lot to this, too, and Liz and I are going to tag team it, and Liz is up first.
All right, welcome back from the break. So we'll be covering government transparency laws. I'm going to start with Form 700 disclosures. So the Form 700 disclosure requirements stem from the Political Reform Act conflict of interest rules and the discussion that we had earlier this evening. These disclosure requirements are useful in identifying potential conflicts of interest that may arise from from your work with the city. Public officials are required to disclose specific financial information annually on a Form 700. It can also be completed when, it also needs to be completed when assuming office or upon leaving office within 30 days. The city has a net file system that maintains all of our Form 700s. It's publicly available, so they are public records. Just to highlight on the public officials section, we have elected, appointed officials, and certain employees that are in our conflict of interest code. The one thing that I wanted to highlight, and it's not on there, are that certain consultants that are participating in governmental decisions may be required, and normally it's in their contract where we would require them to be Form 700 filers. So every agency has to adopt a conflict of interest code pursuant to the Political Reform Act. The code is reviewed and updated every 2 years. Our code includes 5 disclosure categories and can be found on the clerk's website. The code must also include all positions within the agency that are involved in making or participating in making government decisions, which may foreseeably have a financial effect or material effect on any financial interest of an employee, public official, potentially the consultants. So depending on the public official's designated categories, these are some of the financial interests that you would need to disclose. It includes income, real property, investments, business positions, loans, gifts, $50 or more, travel payments, business entity ownership, that's 10% or greater. So these rules can be very complex. The Form 700 instructions are very detailed, and they can be pretty helpful when you're trying to figure out what you need to complete. If it's unclear, please consult the city clerk's office, city attorney's office. While we can't give you personal legal advice, we're happy to help guide you and steer you in the right direction to find an answer. Also, there's training and resources at the FPPC website as well. So this is kind of a summary of the reportable interests and non-reportable interests. I won't go through each one, but some things I do want to highlight. So while individual stocks may need to be reported if it's valued at $2,000 or more, if you have bonds or mutual funds, those do not need to be disclosed. Your personal checking accounts, saving accounts, those don't need to be disclosed. If you have investment property, your rental properties, those all need to be disclosed on your Form 700. However, your personal residence does not need to be disclosed on the document.
Okay, our next quote.
Do you want to say it?
Liz wants me to say this one. Everything that guy just said is bull. It's a PG-13 presentation, so I'm just going to leave it at bull. The movie was made in 1992. Every lawyer I know knows that this movie is ridiculous and does not resemble what we actually do in practice, and we all love it. One of the favorites. Okay. We've got a lot to go through now, so I'm going to, and there's a lot of Brown Act slides, but I want to spend some time on very important set of rules regarding conduct of city business that applies to really probably everybody in this room, right? Everybody in this room has some interaction with public meetings, whether you're an employee providing support for them or doing presentations for it, whether you're a decision maker on a board, on the council or on a board or commission, or whether you're a member of the public, right? Trying to interact with that boards and commissions and make sure you're getting yourself heard. This is a significant part of this, program, and I appreciate you bearing with me on it. The Brown Act itself, a lot of people know it, throw it around, and it's got a history. And it's called the Brown Act because it was authored by Ralph M. Brown. It was an assemblyman from Turlock, California. It was first adopted back in 1953 in an effort to safeguard the public's ability to obtain access to participate in local government meetings and deliberations. The original statute was 686 words. When we used to have books, I brought the book in, that contained the Brown Act. It was a pretty good section of pages. So there's a lot more to it now than there was back when it was a 686-word statute. I think one section of it might be 686 words. It's contained in the Government Code, section 54950 through 54963. It's a great read. I highly recommend for people to look at it. Core principles of the Brown Act are these. The idea is that any local legislative body, and it's in quotes because I'll define it for you, can only deliberate and take action on the public's business at public meetings. Public must be notified in advance of all the meetings on the matters that are going to be considered, and the public must be given access to information and an opportunity to provide input to their decision makers. There's exceptions, we'll talk about those too, but they're limited, right? The whole idea of all of this is that public business should be conducted in public, and in order for that to happen, the public needs to get access, to that. Easy concepts, like most of this, not always easy in practice, and we'll talk about it. It's also not very efficient, right? And a lot of folks criticize government for how inefficient. Why can't you be more like businesses, right? Why can't you be more efficient? Why can't you make your decisions more quickly? There's a bunch of different reasons for that. This is one of them, right? Things that have to be made in a certain way. The council people just can't, get together, or boards and commissions just can't get together, in ways that any number of different corporations can, particularly smaller ones. So definitely something to be aware of. I told you I would define it. I need to and I will. What are legislative bodies? The Brown Act applies to all local legislative bodies and their members. And what that means is city councils and county boards, right? The primary decision makers. Boards, commissions, and committees created by those primary decision makers. Subcommittees of a legislative body, with some limited exceptions that we'll talk about later on. Regional boards as well are governed by this. VTA, the NCPA. So are bids and P-bids that are created per the Streets and Highways Code, right? There's certain tax structures that collects tax money from property owners or businesses that operate within a certain district in order to support certain activities that help that particular district do better and put on events and potentially have better maintenance and a higher condition of their public facilities than they would otherwise. They're governed by the Brown Act as well, because those are sponsored by government agencies and are considered to be quasi-government agencies in what they do. The Brown Act does not govern the conduct of city staff. It's these decision-making bodies. But that doesn't mean staff doesn't need to be aware of all these rules, because you can be an inadvertent agent of Brown Act violations, and it's your duty as a public employee to be aware and to avoid those things. So another key definition, what is a meeting? It's really one of the things, I'm going to say this a lot probably, at the center of the Brown Act. A lot of things are at the center of the Brown Act, but the concept of a meeting is definitely one of the things that at the center of Brown Act, because whenever you have a meeting, as it's defined, you must make sure you comply with the rules of openness and public access. So a meeting is defined as any congregation of a majority of the members of a legislative body, we just defined that, at the same time and place to hear, discuss, or deliberate an issue in the subject matter jurisdiction of the body. In order for a meeting to happen, no action is actually required. If you're together in the way we're going to talk about in detail, and you're just even deliberating on stuff that's in the public business, that's a meeting too, and the public needs access to it. It includes informal gatherings, with or without attendance or city sponsorship. Okay? So, if city council members went in a group of 4 or more to Mia Vicino after this for more pizza and beer, and they talked about city business, that's a meeting for Brown Act purposes. You're all invited. And training, and we'll talk about that. This is, if you noticed, this was convened as a Brown Act meeting, right? I knew a majority of the council was going to be here, so we called it as a special meeting, because there was a potential for some deliberations or discussions on things that might impact them. I could have argued for an exemption, but part of my advice is, where it's not perfectly clear, what do you err on the side of, right? On the side of following a rule that could apply to you. So we are convened in a public meeting here. What else is a meeting? And here's where things get a little more interesting. Other forms of communications can constitute a meeting in the right combination. Writings, written communications, including emails between a majority of the members, are a meeting under the Brown Act, right? So it can't happen because you can't possibly include the public in the way you would need to in that. If there are intermediary communications, communications between employees or agents on behalf of a majority of the members, right? So in effect, the ultimate result is the majority of the members have been communicated and able to communicate about something. That's a meeting. This doesn't need to happen all at one time. It can happen in a series of communications over a period of time. Those are called serial communications, a chain of communications between members resulting ultimately in a quorum of the members being contacted and engaging on a matter of city business. That's a meeting too. So this concept of a serial meeting is worth talking about a little bit, just so you understand it. And there's really two main kinds of serial meetings. One is known as a daisy chain, right? Just one person talks to another person and that person talks to another person and so on until you get up to a quorum of what would constitute a majority of a legislative body. There's also the concept of a hub and spoke, communication. One person doesn't talk to another and another, but talks to different people, just that one person, and communicates with one. If you add up to 4 with this particular council, that is a meeting, and it is a prohibited engagement. And these things can happen in all different kind of combinations with all different kinds of communications. It doesn't need to just be one, right? An email, then someone talks, and then someone faxes. No one faxes, but in theory, someone faxes. We get a fax every now and then in our office selling us, office like fax machines. It faxes us to sell us a fax machine. Any kind of communications in any combination, can constitute a meeting. So you definitely need to be aware of that. And you'll see this, come up in a couple of our scenarios, I think, here soon. I'm going to skip the examples because the scenarios will illustrate it. There are exceptions to these concepts of meetings, discussed in this next slide. And it's not a meeting, where you might otherwise think it would be, if a majority of the members attend conferences that are open to the public, open and publicized meetings of a local group, open noticed meetings of another legislative body, a social or ceremonial event, or an open noticed meeting of a standing committee. But they can't participate in that meeting. So you can see some of these might present some gray areas, and you really need to seek legal advice first as to whether or not the particular type of this gathering could qualify for the exemption. But really the important rule to remember is just because you're there doesn't mean you can talk city business. These aren't exemptions from other types of communications you might have. You can't go to a conference that's open to the public and gather in a huddle and talk about city business, right? The idea of you being together at a conference that's open to the public and participating and interacting there is okay. But it can't be used as a way for you to communicate with each other on city business. So if 4 or more members of the city council were at a league conference, there's nothing wrong with that, right? You could be even in the same room listening to the same materials. Nothing wrong with that. If multiple council members went to the Classy Bag Affair and even sat at the same table, that's not a good look. But if they're spread out amongst, and not interacting and talking about city business, it's okay for them to be there. It's not a meeting. It's one of the exempt things. Or if a member was interested in the activities, for example, of one of the committees, and there was otherwise 3 members of the council on that committee, if that person went, not necessarily a best practice, but not a violation either, right? Because they're not participating. As long as they don't participate and they're just observing, it's okay. So some of these exemptions do come into play, and we'll talk about them a little bit more. Meeting exemptions continue. These are typical communications that occur, right? A memorandum from the city manager or the city attorney to all city council members. It's an email, right? and we're communicating with all of them at the same time, but it's just one-way communication, right? We're providing them information. That's not a meeting. That's just us communicating information to them. If they start talking to each other about it, and their series of emails, results in 4 of them communicating about it, that's a meeting, and that would be a problem. But just this communication itself is not. Communications for purposes of calling a special meeting or setting an agenda are also not meetings under the Brown Act. In fact, there's a specific exemption for communications amongst a majority of a legislative body for mere purposes of setting a meeting. There is a risk here, though. If you're communicating about purposes of setting a meeting and you talk about what that meeting is going to be about, that's kind of a hybrid communication, right? It's kind of a, what are we going to meet about? Oh, let's meet about this thing. I'm interested in saying this thing. Okay, I can meet. I'm interested in that too. That's not setting a meeting any longer, right? That's starting to talk about, the city business. And in fact, we had a policy here for the council to set special meetings that we thought could be improved, and actually recently did approve it, and the council approved it in order to make sure that now the processes we have for setting special meetings are run through staff, right, and managed in a way so there's not an inadvertent violation of the Brown Act. It'll result in purely the setting of the meeting itself. In addition, individual contacts or conversations between less than a majority of the members, and members of the public, are not problems. However, do need to be careful with that, right? Say your legislative body is 9 people and 4 is required for a majority. If 4 of those people get together and talk about something, you're pretty darn close, right, to having just one more communication result in a violation of the Brown Act. So getting close to the line is also, even though it's not unlawful, from a best practice standpoint, can be an issue, and we typically advise to steer clear of that. So, Brown Act communications, tips, knowing these rules. Council members, board members, when talking to a colleague about city business, check first to see who else they've spoken to, right? You might not always know that, right? If you're just talking to one other member and you start talking about saying there's nothing wrong with that. If you're on a board or commission and you go, hey, I've got some thoughts about this policy, that we're making. Oh yeah, let's talk about it. Then you find out that person's talked to 2 other people, right? If it's a 7-member board, you've in effect had a secret meeting, right, under the Brown Act. Beware of intermediary communications between employees or agents, right? Staff members also need to exercise some discretion here. If you've had communications with another council person or another planning or commissioner, you can't go in and go, hey, I just talked to this person and they said this. You're in effect acting as an agent in order to form a decision, in effect, outside of the public eye, and it's prohibited. If staff needs to communicate with members by email, it's a good practice to BCC those members, right? So you're not setting up the risk of a reply all, type of communication that might inadvertently violate the Brown Act. Again, practical things to think about. You have to be, as a public agency, you have to be very careful and cautious with your communications so you don't end up crossing the line. Okay. Oh, good. We've got another question. Yes, quick one.
Social media?
We're going to have a bunch of slides on social media. Yep, so hang in there. Yeah, more than you want. But you started it, so it's your own fault. I added a couple slides because you've talked about it. Okay, your next movie question. I don't mind if you try my case for me, Your Honor, but for God's sakes, don't lose it. 1982 movie, fantastic movie. One of my favorites. Sorry, this is clearly about me, this whole quiz. I think I've made that clear. But I know this one's hard. I know this one's hard, so I've given you a clue, a terrible clue. That is the judge to whom this line is spoken. I don't mind if you try my case for me, but for God's sakes, don't lose it. That's who he's talking to. All right? Okay, still Brown Act. We've defined legislative body. We've defined a meeting. We've talked about some best practices in avoiding having an inadvertent meeting. Now let's talk about how some of these principles and practice, these concepts are put into practice, right? The agenda. The agenda. The first element of putting things into practice is the meeting agenda, and we're all familiar with this. A lot of us, as part of our daily lives, we live and breathe agendas, right? You're putting together the agenda. It's got a really important purpose and function. And under the Brown Act, its purpose and function, aside from just practical aspects of organizing a meeting, is to inform the public of what's going to be discussed at a meeting so they can determine whether or not they're going to monitor or participate in that meeting, right? That's the core. We're trying to be efficient and have things organized in a way that we can, go through things and have them be listed. But this is what the Brown Act says about it. This is its purpose. There's different requirements for an agenda in order to serve this purpose. The first one is notice, right? Agendas, in order to give people notice and an opportunity to participate for regular meetings, need to be posted 72 hours in advance. For a special meeting like this one, the requirement is 24 hours in advance. Posting includes mailing it to people who have requested that they receive either an email or even a physical mail, I think, notification. They're allowed to ask you that, and you need to comply with that. And now it also needs to be posted prominently on the internet, on your website, and it needs to be made searchable. So the standard says technology, improves, the technological requirements are also increased. There's also requirements now, right, to have our website be in multiple languages, right, or that people can be able to access things that way. All in the interest of improving access. So you've got notice. What needs to be on the agenda? Brown Act requires any agenda to indicate the location and time of your meeting, right, of course. Needs to contain a description, though, of the items to be discussed. And that description needs to really describe the issue in a way that people understand what's going to happen. It doesn't need to be longer than 20 words, the title, for it, but it should make clear to a member of the public what will be discussed and what action is being sought with respect to that item. Is it approval? Is it direction? Is it acceptance? What is it? And I'm sorry, there could be in a couple of your handouts, a couple of the slides got put out of order. This is one of the sections I think they are out of order, so apologies for that. You may need to hop back and forth here a little bit. Agenda title examples. Here's one. Discuss downtown precise plan. A topic of interest to some people in this room, a lot of people in this room. Does that really tell you what's going on? Discuss downtown precise plan? How about this one? Presentation of and possible action on, sounds like a lawyer, downtown precise plan to change land uses and development standards in area bordered by Fenton, Lafayette, Madison, and Homestead. That tells you what's going on, right? It's not the full, I don't know if my geography is right. I think that's right, approximately right. Is it right?
You mean Benton.
Oh, Fenton. Oh, for God's sakes. It's Benton. That's my typo. That's my typo. I knew it was Benton. So question for you. If that's what it said, could you meet on that topic? You could, right? That's a typo. Yeah. That's a typo. There are some liberties, taken. So here's another one. Fiscal year 2023-24 budget amendments. It's a description of the item. Is that good enough? Not even close, right? Action on, how about this? Action on proposed amendments to the fiscal year 23-24 budget to increase the city attorney's budget by $3 million. Right? Very clear what's going to happen there. I got a red card. Yeah. It wasn't from a council member until that second now, so that's, yeah. It'll be less than $3 million, my request. So don't worry. Don't worry about that one. So you've got to do better than that, clearly. Okay. What you can talk about at meetings, all right? You've gotten your notice, you've got your agenda there, you've presented it. What can you talk about? Only items that are listed and clearly described on a timely posted agenda can be discussed or acted upon at a meeting. As a board or commission member out there, we don't always get to staff you. If something looks like it doesn't really describe what you're being asked to do, don't do that thing. Continue the item. Ask staff to bring it back where you feel like it's a better description of what's going on. What you cannot talk about at meetings. You cannot consider, discuss, deliberate, or act on matters not on the agenda. Otherwise, the only appropriate action is to refer the item back to staff for a future agenda. A brief response to questions are okay if you're trying to figure out, right, what's going on. You can have a certain amount of, and you'll see me struggle with this sometime. I try to give some liberty as people are trying to sort out and understand things. But you can't start deliberating on something and going down a path on something that's not on the agenda. There are limited exceptions for this. In the event of an emergency, right? If something comes up and a majority vote determines that an emergency exists, it needs to be a real emergency, right? Like some kind of natural disaster or terrorist attack, God forbid, or a major work stoppage. Those are things that are potential emergency actions. There's also an urgency concept. If there's a need for immediate action on an important matter and you didn't, the staff or whoever didn't have awareness of it until after the agenda is posted, with an urgency vote, 4/5 vote, the item can be added to the agenda. Tended to be rare circumstances, but of course accommodations need to be made for things that come up. The Brown Act also requires that meetings be held at a qualified location. There's some exceptions to that. I'm not going to dig into this too much. Obviously, you would consult, with the lawyer's office if in fact there was a desire for this kind of meeting. Boards and commissions certainly would need to do that. But the location does need to be ADA accessible. That's a provision of both ADA law and under the Brown Act. And there is a concept for remote participation that we'll talk about briefly by both members of the legislative body and the public with certain requirements as to how that happens, right? So you needed to be at a certain location. My old city had some specific rules in addition to the Brown Act rules. We just have the Brown Act rules here in Santa Clara. And remote participation is allowed under state law. Remote meetings, here we go. I was right. We are going to talk about it. And I'm not going to dig into this too much, too. There's a history for this, right? This has been allowed for 20 plus years, right? The standard, remote participation that people are familiar with, right? You need to put your name, in your location of where you're at on the agenda, and potentially people can have access, to you there and be able to testify from where you're at. A little impractical, but it's been in place for a while. There's different kind of COVID rules and some permutations of that. There's now a rule under AB 2449 that does allow for remote participation by a certain number of council members. You always have to have a quorum of the legislative body, in the room in order to invoke this. But if there's a for-cause situation or an emergency situation with the vote of the council, in that case, you can actually have people participating remotely. Makes sense, right? Things come up. People need to be places. You want to continue. You want to allow everybody to participate. You want the city to be able to continue to conduct business, unlike Congress. And you. And this allows you to do that. There are some requirements for public participation where if you're doing it this way, the public needs to have, the ability to interact in that same way as well. But it is something that this agency does frequently. It's well supported by the city clerk's office, and it's certainly appropriate. Okay. Another hard one. Lawyer movie quote number 8. I'm your dream client. I'm the most fun, I'm rich, and I'm always in trouble. Johnny Depp. That's real life. That's not the movie. That's not a movie. That's real life. Yeah. 1996. This one's pretty hard. Does anyone have any clue of what the answer is to this? I'm going to give you a hint. And if you get the movie and the actors in it, I'm going to give you, everyone gets 1 point. I'm going to tell you the main actor in it. It's Woody Harrelson. It's the main actor in this movie. Okay? Everyone write down Woody Harrelson. You get 1 point, but I'm not telling you anymore. Okay? All right, Brown Act, subcommittees. Got to keep cranking here. Is it subcommittees now? Yes, subcommittees. So I told you that there were some special rules here. And I told you that Brown Act generally applies to all boards, commissions, committees, subcommittees, and other bodies that are created by a local agency. It doesn't matter how you've created it. If you've created by charter, you've created by resolution, or a formal action of the legislative body. It requires some formal action of the legislative body. The Brown Act applies to those things. It applies where that body is permanent, temporary, advisory, or decision-making. Some of you are on boards and commissions that are purely advisory. That's not an insult, it's just your advisory, right? You're making recommendations. It's actually a very important, city function, and it provides support to the folks you're making your recommendations to. Doesn't matter if you're advisory, you still need to comply, with the Brown Act. There is a limited exception. There's this concept of an ad hoc subcommittee. A lot of people throw around the term ad hoc in normal parlance, but this is a very special concept with that. An ad hoc subcommittee can be exempt from the Brown Act and can meet privately without any of the notice, public input, requirements for efficiency purposes. But that ad hoc subcommittee needs to be comprised solely of less than a quorum of the members of the appointing body, right? So less than a quorum of whoever the entity is. So in the case of the council, it would have to be 3, right, or less folks. You can't have any outside parties on that. If you want an expert on that, hey, we're going to study SVP, sustainable power sources above and beyond what we have already. Let's get a consultant, from the energy industry on that. You could, but you're now a Brown Act committee, right? You can't have that person participate. That person can come and present to you, but they can't be part of that committee. Outside people can't be on it. They can't have continuing jurisdiction over a particular subject matter. Needs to be a specific purpose, and that purpose needs to have a limited duration. 6 months is considered the safe harbor for that. Up to a year is not uncommon, either, and I'm not opposed to that, as long as it has a very discrete, specific purpose and a very discrete, once you're done with this, the group goes away. These are things that are created all the time to allow a group, a subgroup, of the legislative body to really dig into something and focus on that thing. And who knows when they're going to be able to meet or get people to come, present to them. It gives some flexibility. Ultimately, of course, any decision would need to come back to the legislative body for their approval. But this is an exemption, and it's not uncommonly used. Staff-created citizen business committees are also exempt. I think the chief has a citizens advisory committee that I think he created that's advisory to him. It's not a Brown Act committee. It could be. You could run it that way, but it doesn't need to be because it's staff created. There's a lot of gray areas kind of in this, and there's a lot of criteria. So don't be forming ad hoc subcommittees willy-nilly, please. You need to advise. You need to consult with us. But it is an option out there. Quickly on closed session. At the beginning of the Brown Act section, I talked about how exceptions to this to the concept of open meetings was limited, and that's true, but exceptions do exist. And this slide summarizes them. I think it's all of them. There might be 1 or 2 other ones. And it makes sense, right? There are things that the council can meet on in private and should meet on in private, in closed session, or also known as executive session, when to do otherwise would compromise the public interest, right? Discussions or negotiations that might be having, litigation strategies they might be having, personnel negotiations where terms and conditions are being discussed or privacy interests might be implicated. All those are things that ought not to happen with public scrutiny. If decisions are ultimately made, right, those need to come out for public approval, but along the way, getting to those decisions can happen in closed session. And the most common of these, and we've listed them up here, are real property negotiations, right? Existing or anticipated litigation, labor negotiations, personnel evaluations, all those things typically do, appropriately so, in closed session. The discussions of what you can talk about in there, and I'm the one presiding over that, are necessarily limited, right? Again, you can't use a thing that gets you into a private session to discuss anything you want. It needs to be focused on the actual exemption that's identified. And in real estate negotiations, it's very, very constrained. The general rule for boards and commissions is that there's no lawful reason for you to go into closed session, so don't do it. There are instances where Civil Service Commission, right, might have personnel decisions that they're being made. In theory, Planning Commission might, if they're the final arbiter of a particular decision, and there are legal issues in you making your decision, that you would need to be briefed on. But very rare circumstances, don't do it without the advice of counsel. Confidentiality, things in closed session, right, that are talked about are inherently confidential, and there's limits on the ability for those things to be disclosed. The confidential information that can't be disclosed are the things that you're talking about that allowed you to be there and discuss those things in the first place, right? Real estate negotiating positions, labor talks, city vulnerabilities or settlements, right? You can't be, if you're talking with a labor group and you're a person participating in that, go tell the labor group what negotiating authority you just gave here, folks. You can't do that for a real estate negotiation, right? So there's limits on that. There are things that can be disclosed, and even those things can be disclosed if a majority of that body votes and decides it. It's not sacrosanct, right? The majority of them gets to decide that. But it's considered a very serious thing and a violation of your duty, and there's penalties for unauthorized disclosures, which could include referral to a grand jury, injunctive relief, disciplinary action. Not a good thing to do, and compromises, again, self over the interest, compromises the interests of the city. There is a reporting out obligation in closed session. You'll hear me doing that. There's seldom a reportable action because it only relates to final actions that are taken to closed session, and most discussions in closed session end up in things that come back ultimately for public approval by the council. So you'll frequently hear me report out nothing. There's no reportable action. But if there is a final action that's taken, you also need to report it out. And I would come out afterwards and communicate that to the public. Rights of the public. Rights of the public are obviously sacrosanct here. That's the whole idea of the Brown Act. And they're listed here on the slide. You can attend, observe, and speak at meetings. You can attend and speak without being required to give your identifying information. We ask, right, because it's helpful to know, for everybody to know, who you are, where you live. You ask, but you're actually not, you can't mandate it. People can say, I don't want to tell you who I am. I don't want to tell you where I live. That's their right. People can record meetings, take audio or video, of meetings. You don't really need to do that the way we have them recorded, but if people want to create their own tape of that, they're allowed. They also have a right to review the agendas and other documents before the board acts. In most cases, with some exceptions, at the same time that information is provided to the board, so everybody's kind of on equal footing. They can also have documents mailed to them, obtain videos, and they also have the right to criticize or complain about the legislative body or members of the legislative body or how the city conducts in business, right? You don't have to come in with butterflies, and cake, when you're on the mic. You're allowed to be very critical. There are some limits to that, right? And I know there's a lot of behavioral standards, and there's part of the code of ethics, right, is intended to apply to everyone engaging, the community. And again, worthwhile everybody looking at Santa Clara's code of ethics to address that. But it's also First Amendment rights that people have, right? That applies as well. So the rights of the public are manifest and they're reflected in a lot of the provisions of the Brown Act. Public comment at meetings isn't unlimited, however, and local agencies are allowed to make rules in order that everyone gets an opportunity to speak, right, and they can go about the city business. You can impose reasonable time limits, and the current city council time limit for agendized item is 2 minutes. For non-agendized item, you also must, at least at regular meetings, provide an opportunity for the members to address the council on things that aren't on the agenda. They ought to be in the city's jurisdiction, but doesn't need to be on the agenda for people to come and talk about that, at least within the purview. This is done here under public presentations, as a lot of you know. And there's rules about that, though, when you talk under public presentations. There can't be any action taken on a matter that on a public presentation. No discussions or deliberations can occur. You can ask a question. You can refer it a little bit, again, to understand what the person's saying, but you're not supposed to really deliberate or really engage on that. The matter can be referred to staff for some further information or report. Or if it's a person complaining about something and the mayor, for example, might know, hey, the public, you should be talking to the public works director. They're back there, right? Go talk to the public works director. All that stuff's okay. It's just you can't all of a sudden have an item that's not on the agenda where it's discussed and actions being taken. I think I talked about this already. It's 3 minutes for public presentations, and typically I think boards and commissions adopt the same rules. You're entitled to adopt some different rules. Even the council can, under the circumstances, adjust the amount of time that people are afforded to speak. But the key thing is that you do it fairly, right? You don't say, okay, people in favor get 2 minutes and people against get 1, or the first 10 people get 5 and the next 6 get 2. It's got to be in a thoughtful, consistent way, ideally done in the beginning of whatever the session is. I think I may have talked about a number of these things already. Special meetings, you must allow comment, but only on the items that are on the agenda. And a special rule now for non-English speakers. If you do not speak English, you're not lawfully required to have an interpreter for that person, I don't think. But that person does get, if they have someone interpreting them for them, get twice the time, right? Because they're saying the thing and then it needs to be interpreted for you. So if your limit's 2 minutes and a person has somebody interpreting for them, they get 4. So a good thing to keep in mind. And again, the whole idea about increasing access. Social media risks. Here we go. All right.
Go ahead.
Oh, question. Sure. Quick one.
So are there rules for zoning, and how is that?
That's done on a local level. The Brown Act doesn't address that. And so I don't know if we have specific rules here that design that, but I think there's a pattern in practice that allows the donation of time and the aggregation of time that the presiding officer manages. Yeah, but not in the Brown Act. I don't think it doesn't speak to it, does it? The Brown Act itself. It's a matter of local rule. So you can do that, but it's a matter of local rule. So social media. 12 years ago, I gave this presentation. I had no social media slide. 8 years ago, this is the slide I had. Social media creates increased risk of serial meetings. If you think about it, it's another form of communication that other people see and can interact with. It also creates a risk of bias and predetermination. We'll talk about that in a little bit, right? If you're on social media saying what you think about something, and you're supposed to be reserving your judgment about that, you're not really reserving your judgment if you're out on social media saying what you think. Emails, texts, tweets, or posts during a meeting also can be an issue because they deny public access to the decision-making process. It's not unlawful. Unlawful, you can do it. We'll talk about PRA in a minute. But creates risks, right? And Brown Act applies for sure, right? But at the time and still, there's really no case law that talks about how these rules work. However, there is now state law that gives us some clarity on how all of this works. AB 992 went into effect on January 1st, 2021. Really, it's the first statutory guidance in an otherwise challenging and still evolving area. And under AB 992, a public official may communicate on social media, of course, right? It's a way that people communicate. But they're supposed to communicate to answer questions, provide information to the public, or solicit information from the public regarding matter within the legislative body's subject matter jurisdiction, right? You can do those things. Those are perfectly logical and appropriate ways to use social media. However, you may not, excuse our clumsy, that's probably me. I probably went into that slide just before and made it look like that. A public official may not, though, use any social media platform to discuss amongst themselves official business or respond directly to any communication on social media regarding a matter within the subject matter jurisdiction of the legislative body that is made, posted, or shared by another member of the legislative body. Remember, I talked about communications that would be okay, right? Between less than a quorum, right? You can communicate. Risky if you communicate up to the level of the quorum, but you can communicate less than a quorum on that. This goes further and says a single contact between one public official and another normally would not constitute a serial meeting. The AB 992 prohibitions go further. You cannot communicate using social media in that matter, between the two of you. So an example of what's prohibited is even as something as a comment or an emoji in response to another public official's Facebook post, you're not supposed to do that. assuming you both serve on the same legislative body. So definitely, for anybody who's on legislative bodies here making decisions, be aware of AB 992. So, an example, little practice tip of a good post, versus a bad post. A good post, in terms of using social media, could be something like, hey, City Council is going to consider Silicon Valley Power rate adjustments at our January 9th meeting. Please come and share your views, right? That's communicating with the public. You're letting them know a decision's going to be made. You're giving them a heads up, right, about when they should attend. A not so good one would be someone who says, hey, Gold Digger LLC proposal to dam Stevens Creek and build a Panning for Gold theme park is absurd and violates environmental laws. Please join me in the council majority in opposing their project application at our January 9th meeting. There's a whole lot wrong with this communication, right? If there's a permit that you're supposed to be deciding on, it's a terrible idea, right? But if it's a permit that you're being decided on, you're basically telling people you already made your decision on that. And we'll talk about this later. If it's quasi-judicial hearing, that's a very serious problem. You're also saying, please join me in the council majority. You're basically declaring that council majority has interacted or decided something and that you could have been a part of. Terrible, terrible communication. The first one's great. Second one's not good. So there's also limits in social media on internet-based platforms. In effect, if you create a platform that's open and accessible to the public, you have to let people participate in that, right? If you're using that as a way of you communicating about city business. You don't get to approve or disapprove, people. You cannot block them for participating unless they're otherwise violating, the terms of service. It applies to comments, retweets, dislikes, smiley faces, sad faces, screenshots, reposting, all these other different apps. I probably less now. TikTok's on there. That's somewhat modern. So be aware of that. If you're using social media in that way, don't be careful about blocking people. There's also an overall, that's the under 992. There's also First Amendment concepts that also, in effect, say the same thing, right? If you're blocking people from communicating with you regarding city business, and you're otherwise using your public platform to inform constituents about information related to the jurisdiction, that social media page is in effect related to your official duties, and you need to be aware of First Amendment restrictions on your ability to block participation. There's some nuances to it, but there's a small audience for that, so I'm going to keep going. So, the end of the Brown Act, I think. Are we at the end of the Brown Act? Yes. Violations and consequences. There's some serious repercussions, appropriately so, for folks who conduct the public's business out of the public's view. There's civil remedies that can be brought by any interested person, actually, or by the district attorney. It can result in the invalidation of the action, that was taken. It could even void past acts. You can get injunctive or declaratory relief to prevent future violations. There's procedural requirements that allow you to handle things in a certain way with notice and an opportunity to correct. But if you fight it as a public agency and you lose, your plaintiff also gets attorney's fees, even if you just lose a little bit. So not to be taken lightly, and there's serious remedies that can occur. More serious still, of course, is a member who's responsible for violating the Brown Act may be subject to a misdemeanor, a criminal penalty even, if there's a specific intent to deprive the public of information. Usually this is an intent crime. A criminal aspect of this is very, very rare, but it's possible. But I think the last one is really the most important one, right? And we've been talking about this since the beginning about this with ethics training is the worst part about this is the loss of public trust, right? We rely on public support, public input, public volunteers, on boards and commissions in order to inform us about, in my case, information that helps me advise the council, in decision maker or other boards and commissions, in the other boards and commissions instance, getting information and having a relationship with the public so that you can use that in order to make the best possible decision. When you lose the public trust by not inviting them in and in violating that, it's really going to be hard to get city business done. So the consequences for me are the first couple, but the third one, I think we'd all agree, is probably the most significant. So, Brown Act practice tips. After all of that, avoid sharing information about another council, committee, commission member's views. Right? If you're doing that, you're marching up the tree, climbing the tree of headed to a meeting. Do not direct or CC emails to a quorum or more of your council board colleagues or reply all on city business. Refrain from public statements, including the use of social media that states final positions on matters that are pending before you. Review agendas in advance of meetings and think about the Brown Act parameters, right? What is this all about? What kind of decision am I being asked to make? Is it okay for me to propose something different, in this context? Reach out for input on that if you have that in mind. Don't discuss an item not on the agenda. Instead, refer it to staff, right, with the vote of the majority of the body in order to report back to you. Don't forget, particularly for board chairs and employee liaisons, in support of them, to allow for public input and apply whatever rules we have that apply to that in an even-handed way. We're all kind of in it together up there on the dais, and so reminding each other, oh, we didn't go to the public, or this person still needs to speak. Don't go into closed session without the advice and the presence of your city attorney or one of his staff members, their staff members. When in doubt, don't act. We talked about that. If there's any ambiguity about what you're being asked to do and you don't think it's properly noticed, trail it to the next meeting and make sure that gets addressed. If unclear, of course, ideally in advance, seek advice from the city attorney's office. I'm always available. I work all the time, so if something comes up in process and there's a board liaison that can reach out to me, don't hesitate to ask that as well. Might not be able to answer it on the fly, but certainly available to do that. And then avoid interactions, version of the social media. You want an advocacy on social media on pending actions before your board. So a lot to think about. Hopefully that was helpful to you. Everyone needs to have a good understanding of this in order to fulfill your responsibilities, because a lot of you are either at meetings, supporting meetings, or participating in meetings as a member of the public. So our next question, we're on lawyer quote, movie quote 9. There's only 10 of them, so you can be relieved that we're coming to the end of this. Another one of my favorites, 1995. Daddy's a litigator. Those are the scariest kind of lawyers. He's so good he gets paid $500 an hour just to fight with people. But he fights with me for free because I'm his daughter. Great quote. I'll give you a clue. It's not a lawyer movie per se. There's lawyer things going on. It's a fantastic movie. I think Member Becker knows what movie this is, I'm guessing. Maybe he doesn't.
Did both of you guys get together on this, or was it just?
What's that?
Was it just you that came up with this, or both of you?
Oh, this is my.
She's going like this.
Yeah. No, that's me. Yeah, I'm to blame. Okay, so we're going to keep cranking here because we're getting near the end. Liz is up with Public Records Act.
And the Public Records Act in our presentation doesn't get as extensive of a treatment as the Brown Act does, but this is a really core part of city business and transparency for public agencies. The Public Records Act was modeled after the Freedom for Information Act, the Federal Freedom for Information Act, or FOIA. And just this year, the state just reorganized the government code for this section. So what we formerly termed the government code under 6250 exec, it's now starting at 7920. And it's a bunch of new sections that we need to start memorizing for our purposes when we're disclosing public records. So the public has a right to see records related to the conduct of city's business. The government must maintain and be prepared to provide public records in a timely manner. And what constitutes a public record is very, very broadly defined. The definition of a public record is defined in applicable statutes, city business practices, or policies. In the absence of a specific legal definition, a record is the document or information generated as the final output of a business process or business decision. And a record can be in any format. It could be physical, electronic, structured, unstructured, and it will be retained in accordance with the city's record retention schedule. And that's a retention schedule that we are going to be in the process of updating very soon. So city staff will be provided the new record retention schedule when we get to that. City business conducted on private devices or accounts is also subject to the PRA. This is as a result of the San Jose case. So any records on your personal devices that is related to city business must be kept and disclosed. However, not all information is public or disclosable. There are many exemptions in the government code as well as other code sections that either exempt or protect certain information. This includes private information about individuals, personal information about employees, like the personnel records aren't typically disclosed, drafts or working copies of transitory documents, details about security and critical infrastructure, privileged documents such as attorney-client work privilege or work product, deliberative process, and finally we have a balancing test. This is the balancing of competing interests about whether the public benefit of disclosure versus the need or rights to privacy. This section is used to kind of balance the privacy interests of certain individuals. For example, one are complaints. When citizens file complaints with the city, to avoid having a chilling effect, we will redact their personal information, but disclose the complaint to the public. So one of the big things and the difficult things for us as we do get a lot of PRA requests is responsiveness. A response must be provided within 10 days of the request. This doesn't mean that you'll get the records within 10 days, but we are obligated to provide a response within 10 days. If a record is readily available, we do have an obligation to provide that. So if it's something that we can provide, we should be providing it as quickly as possible. There is additional time requests that can be allowed in certain circumstances as we're searching for records, reviewing records to make sure that we are able to disclose them. So these are some of the additional duties that are required in response to a PRA request. We must provide the record as quickly as possible. Help the requester formulate an effective request. So a lot of times we will talk to the requester when it's very broad to help try to narrow down or try to get the record that they're actually requesting. We'll explain why records are being withheld. So we have an obligation, if we are exempting a certain record, to disclose why that record is not being provided. The city can charge reasonable copy fees, and inspection of the records at the city is also free. However, we can't charge for staff time while we're searching for those records, although if we need to create a record for some reason, we can charge for that request. So here are some practice tips. Be prepared to promptly disclose records if requested. We do have that 10-day window to kind of respond to whether or not records exist or if we're searching. Communicate carefully and especially in emails. So we don't want to create so many records that we have to dig through. So if you're communicating, use emails wisely. Search every place a record is reasonably likely to be located. So searching your email, your personal devices, but also there could be records that you're holding on your computer or just in your office that may be subject to disclosure. And you want to also document your search. So when you're running a search, keep a record of all the avenues of where you're looking for those records. It's best not to use a private account or device to conduct city business. So if you don't want to kind of commingle your personal information with public records, then avoid using any of your personal devices. If you do, just make sure that you're keeping those records and that they might be subject to disclosure. Okay, so this is a public record I do want to discuss, and this is a local rule, a local calendaring rule that we have, and it applies to elected officials, city manager, city attorney, the assistant deputy city managers, department heads, and certain designated managers. And all non-internal city-related appointments, meetings, public events, speaking engagements, meetings with citizens, developers, unions, et cetera, and lobbyists need to be disclosed on these individual city calendars. Non-internal appointments must include certain details, and that includes name, title, organization, and statement of the issues discussed. Calendars are a public record, and certain officials are required to publish their calendars monthly. All right, so Glenn, we have a few hypothetical scenarios.
Yeah, but boy, we're going to have to probably just pick a couple of them, huh?
Okay, and I can run around with the mic if we wanted to have people answer.
Yeah, very good. Sorry, we're going, this is very tough to get all this material in, and we've still got some material we need to teach you, but these hypotheticals are good, so we've got 6 of them. We're not going to do 6 of them. We'll do at least a couple of them. Let's do the first one since there are a number of Form 700 filers here. Petra Oleum is a designated Form 700 filer on the SVP Resource Advisory Committee and a partner in a business entity with her sibling, each with a 50% partner in the business. Sorry, that's drafted wrong. The business provides energy facilities consulting services throughout Southern California. Does Petra need to report that on her Form 700? And what other issues does this present? Okay, who thinks she needs to report her business with her sibling on her Form 700 report based on these facts? I see mostly greens, but I see a red too here, a red. Why not?
Silicon Valley Power and Southern California.
I'm sorry.
I'll repeat what he said.
Yeah.
So he basically highlighted the fact that we're referencing Silicon Valley Power as the but the business entity is actually in Southern California.
Yeah, comment on that?
On that one, that's correct, right? So on our Form
Great point.
700, we are supposed to disclose what's within our jurisdiction. If the work is primarily in Southern California, it's likely it's not going to be doing any work up here. So
There's an argument here. Very good. That was brave. There was an argument here that that's not reportable because it's not business conduct within the area. To the extent it might creep into this area, right, and is broader, might it be safer to disclose? Yeah. Pardon?
Or if they buy power from them, or if they're green energy.
Yeah, there's some different, right? But your answer is correct, right? If the business isn't being conducted here, it's not required. But where are we erring on the side of now? If they might do business in the future, or there's some kind of interrelationship, disclose the interest. When in doubt, disclose. We'll skip the other issues. We'll go to the next one. Olden Gray has a $36,000 individual retirement account with an investment firm. The account contains stock in several companies doing business in the city. One of the stock holdings, AARP Computers, Inc., reached a value of $2,500 during the reporting period. Does Olden need to report this on their Form 700? Yes is green, red is no. I see a lot of greens, and the greens are right. What's the break point for disclosure? $2,000, $2,500 here. If this was a stock that was held in a mutual fund, right, as opposed to an individual stock, there are exemptions for that. But this doesn't say that, right? It says it's an individually owned stock. Let's do one last one on this page. Ezra Chatty, a recent sworn-in Santa Clara planning commissioner, sent a private email to Ernie and Oscar, 2 experienced planning commissioners, asking questions about Oscar's controversial car wash project on their agenda to be considered at a public hearing the following week. To keep everyone in the loop, Ms. Chatty BC'd the mayor, the city manager, and the city attorney. Is Ms. Chatty's email to Ernie considered a meeting under the Brown Act? Is this a meeting? I see greens, and I see a lot of indecisiveness.
How many members of the planning?
You're not talking yet. You're voting. Green is Ms. Chatty's email considered a meeting? Has Ms. Chatty created a meeting? I see greens, I see reds. Why is this a meeting? Who wants to speak to that? Yeah, and how many people are included in that communication? How many did we get to?
Well, you've got a majority of the council, because you've got 3. You've got
Oh, it's planning commission.
Yeah.
plus the mayor.
You got 3 planning commissioners, a mayor,
Yeah.
a city manager, city attorney. Those are all separate things, though, right?
The council.
So your planning commission is 7. You have to get to 4. Does it get to 4? Mayor doesn't count. Mayor's not on the planning commission. Staff people don't count. I knew I would trick somebody. And I know.
Still not a good idea.
It's still not a good idea, right? So that's what you were probably thinking. You're getting close to the number, right? Which is always ill-advised. But technically, right, there's some miscellaneous people in there. They didn't cross the line. What other issues does this present? Anybody?
It's always been a perception. If there's a perception, it's kind of a key word too. If the public perceives it, then it's an issue. And this is pretty darn close to it.
Pretty darn close. I would agree with that. The other fact that's in here, if you noticed, is that Oscar is involved, right? It says it's his car wash.
So wouldn't he have to recuse himself on the actual?
And what does recusal mean? Only when you get to the vote? Everything up in between. So the other thing that this indicates to you is what's Oscar doing talking with people about a project where he has to recuse himself, right? Oscar needs to totally distance himself from this. Very good. We have some more, but unfortunately, we need to
Go through process.
dive into the rest of the stuff.
All right, we'll quickly do this, this one.
Okay.
Which,
Yeah, do this one.
yeah. The first thing we do is let's kill all the lawyers.
Okay. The
So
first
this
thing we
is
do.
not a movie.
The first thing we do, let's kill all the lawyers. Lawyer movie quote. No, the movie is in quotes, and it's circa 1596. Okay, so if you name the play, right? It's a play. That's worth 3 points in this case. So mark, if you get it right, mark 3 points for yourself. Remember, I won't remember, so you have to remember. And if you tell who said it, that's worth 2 points. And if you explain why this isn't a criticism of lawyers, it's worth 50 points. No, it's worth 2 points. That's worth 2 points. If you explain why this isn't a criticism for lawyers, it's worth 2 points. Okay? Fair process laws. Okay. This is our last article. Thanks for hanging in there. We're going to crank through this. We need to talk about it, but I also want to get to the end. And if anybody has any final questions, or if anybody from the public wants to say anything, I want to give them the opportunity as well. But we're going to crank on fair process laws. I think Liz and I are going to tag team it, so thank you for bearing with us. Next up is concept of common law bias. This was formerly known, this concept, common law bias, formerly known as the common law doctrine against conflicts of interest. Common law, and you hear this a lot, is law that's established by judicial rulings, right? It's case law, it's court law. When people say common law, it's law made by cases, as opposed to statutes, right? All equally meaningful and governing, but a different form. What common law bias cases say is that it's prohibited for public officials in a matter where there is a high likelihood that their personal interests could be placed above their duty of loyalty to the public, right? They're prohibited from participating in those instances if their personal interests could be placed above their duty of loyalty to the public. A typical personal interest includes financial interests that may not be actually covered by the Political Reform Act, right? It may not be quite at the level or of the type that would trigger an actual financial interest, but it still may be significant, or a significant impact to the decision upon a close family member, friend, or affiliated group, all right? An example of this is a planning commissioner whose daughter is seeking a conditional use permit for a new car wash business. The daughter is grown and not a dependent, and the planning commissioner has no financial interest in the business. Shouldn't the planning commissioner still recuse themselves, right? There's no financial interest. Their kid's on their own. But it's their daughter, right? If it was their third cousin twice removed that they don't know or don't have any interactions with, could they argue there's no real common law bias? If they felt comfortable with that, I think they probably could. There'd be an appearance issue, right, that we'll talk about. But that's how common law bias works. There is an analysis that you need to go through. And this shows it. You look at the subjective and objective components of what's going on. What do you think and feel about the potential for divided loyalty, right? A lot of this is a personal decision. And what might a reasonable observer think, right? What are you thinking? And what might a reasonable observer think about your participation in this? Factors to consider as you're wrestling with this thing is how material is the interest, right? Is it a big matter that you might potentially have an interest in? How close is the relation, right? Son, daughter versus very obscure relationship. Is there an appearance of impropriety that should be avoided, right? We get back to that. We've talked about that a few times. And this concept of appearance of impropriety really is an important one. To preserve the public's confidence in the integrity and the impartiality of the conduct of city's business, public officials are counseled, and I'm counseling you tonight, to avoid even the appearance of impropriety. It's not illegal, right? Because we've not identified any legal issue, with it. But it's very important to the public perceptions of how we conduct ourselves. It's also an important issue and part of the legal canon for lawyers. So it's specific to us as well. At the same time, you've been elected or appointed or hired to make decisions and to do your job. And if you feel like you're not being influenced by personal interests, why should you remove yourself from that duty, right? We talked about this earlier in the ethics principles. These are really things that are at odds with themselves, but they're things that you need to think about. There's no easy answer on how we balance these interests. Again, what would a reasonable person think observing? Are you necessary to the decision, right? If you could avoid being, is there enough people to make the decision, without you? Talk to someone that you trust to balance, these interests. It's a good kind of gut check with yourself. If you do decide to participate or not, explain. It's a good thing to do to explain why you did or you didn't, in a public way, if you have an opportunity to do that. So there's any number of examples of this. Something you need to wrestle with. Not an easy answer. I think there's actually some decent provisions in the Santa Clara's Code of Ethics and Values that talk about this concept. So again, I'm commending you to look at that and consider those provisions. Due process rights. Quickly, is a concept a lot of you have heard about. I didn't get due process, right? It's a concept that originates in the United States Constitution that says no state, government agency of any kind, shall deprive any person of life, liberty, or property without due process of law. And what that means is, in practice, if someone's seeking something from the government or the government's seeking to take something away from somebody, a property right or type of right, that person is entitled to notice, an opportunity to be heard, and they're entitled to a fair and impartial decision maker. There's a lot in that, right? You need to, if a decision's being made, you need to be told about that decision. You need to be given an opportunity to make your arguments about why the decision should or shouldn't be made, and you're entitled to have a fair and impartial decision maker. Another thing that we've talked about that I know the different boards and commissions get briefed on, I think I recently did this with the Planning Commission, is this concept of a quasi-judicial hearing. It's another due process concept. It's basically a decision where the decision maker is acting as if they are a judge. You've got a particular set of facts that's before you, and there's a particular set of rules that you're being asked to apply to those facts in order to say, yes, you can do that, or no, you can't. A typical example of that is an administrative hearing on a code enforcement case, or frequently for planning commissioners and council members, a decision on discretionary permits, right? So this does happen from time to time. Not going to go into it in too much depth because we're jamming here. But I would distinguish a quasi-judicial decision from a legislative decision where you're making a general policy determination, right? You still have to afford people due process and opportunity to participate, but the quasi-judicial decision, because it's specific to a particular person and proposal, and you're applying a set of rules to a particular kind of facts, it creates some additional requirements. Oh, sorry for how this looks. Again, I must have done that. The city has a lot of provisions in its code in order to manage this. There's some references here about how we do it in order to make sure people are given an opportunity to have due process. There's rules that allow a applicant, for example, to get extra time to speak. There's an opportunity for the public to speak, and then the applicant gets an opportunity to rebut. It's all held inside of a public hearing where the decision is supposed to be made only with information that's in the public hearing and based on the evidence of the record. And if any person making a decision has significant information that's material to the decision that they received outside the hearing process, they're supposed to tell people about it, right? So that everybody has the same set of facts that they're basing their determination on. So a lot to this, an important way that we deliver due process, but I'm trying to jam here. Other local requirements, there's any number of different provisions throughout our charter and our code that are intended to afford people due process, right? Specific hearing procedures, notice procedures, rules about how we go about potentially enforcing, the city's code against folks. All of that has built into a due process, and it's a very important concept at every level of government, particularly at the local level of government, because how much impact we have on people's day-to-day lives. So very important to keep in mind. Competiting, we only have a couple slides left, and then we're going to wrap things up, and Liz is going to jam through them.
Okay. We wanted to highlight another fairness aspect of city government, and that's competitive bidding requirements. Most state and local governments require some level of competitive bidding, and the reason for this is to ensure fairness and transparency in the selection of contractors and vendors. It also helps ensure that public funds are spent efficiently and effectively. So competitive bidding generally requires that the public agency widely publicize the contract opportunity, provide information to everyone, and evaluate the criteria for each bid consistently. Public works contracts go to the lowest responsive and responsible bidder. City contracting rules are contained in our Charter Section 1310 and City Code Chapter 2.105. There are some exceptions to the bidding requirements in the Charter for public works. There's an exception for emergency circumstances. And there's also an exception from bidding when the City Council votes that the city uses its own forces, and it's more economical or better for the city to use the city's forces for that. So those are the exceptions for public works. For products and services, there's quite a few. Again, emergency purchases is one of the exceptions. Public agency purchases, so for purchasing from another government body. Cooperative purchases, or what we also call piggyback agreements, and so purchasing from someone else that's already conducted a formal bidding process. And then last is sole source, and sole source is rarely used, but it's used in circumstances where there's only one product or service or vendor that can really provide that product to the city. All right, we want to touch upon incompatible offices. This is Government Code 1099. It prohibits a person from simultaneously holding two public offices that are incompatible. Essentially, it's when two roles can't really serve two different masters. And this is governed by the FPPC, and the Attorney General typically issues opinions on this issue. And it regulates offices that are elected or appointed. Employment with the city doesn't apply in this case, so it has to be an elected or appointed official, and to determine whether the two offices are incompatible. So where one office exercises supervisory, auditing, or removal power over the other. And the consequences for violation of this is that there's an immediate forfeiture of the first office that is held. The next slide is incompatible activities, and this does apply to employees, but not elected officials. So a local agency officer or employee shouldn't engage in any employment or activity for compensation in which it's inconsistent or incompatible with their duties with that local agency. A local agency may define what is prohibited and establish rules for review and approval of outside activities, just to kind of keep a check on potential conflicts coming up in the future. We do have a question here. I don't know if you want to answer it, or should we?
I would go.
Huh?
I would skip.
Yeah, skip it. Okay. And then our last slide is touching upon nepotism. So nepotism is a form of common law bias based on familial relationships. We generally shouldn't participate in matters which involve our family members. Our charter does have an express provision for the city manager, and it prohibits any person related to the city manager by blood or marriage from being eligible for city employment. We also have a CMD, which is our city manager directive for employees, and it contains provisions about employment of relatives and nepotism prohibitions that apply to city employees, and there's a lot about hiring city relatives or even supervising. So there's provisions that apply to employees in that CMD. All right.
You've made it. You've made it. You've made it. As you can see, there's an awful lot to talk about. But if you are an AB 1234 certificate seeker, you have heard all of that you need to hear over a substantially longer period of time than if you had done this online, but hopefully in a way that brings it a little bit more to life, right? Gives you a feel for it, allow to interact with it a little bit, and to get a local flavor, right, of how that applies to you potentially in your circumstances here, and a number of the different local rules here that actually augment what the rules are that govern public officials' conduct under state law. So I hope that was helpful to you. We've got still a couple more matters to go through, but just some concluding thoughts from me. I know you heard about a lot, but really a lot of this can be boiled down into just some essential core thoughts, right? You've heard this theme a lot. Put the public's interest above your own as you conduct yourself, right? An important theme. Obtain no personal gain from your position. There are certain things that are allowed, but certain things that aren't, with clear limits and disclosure requirements. So think about that. Treat people fairly, right? The due process concept. Everyone needs a fair shake. Opportunity to speak to you, opportunity to have you be impartial, opportunity for you to consider all sides. And since a lot of this is more complicated than you think, we had a lot of green and red cards, right? All the time on the fly on this. And even Liz and I, we're like, oh, that's a good point. We'll have to think about that. Some of this stuff's complicated. So seek legal advice. We're not always able to advise you because not everyone here individually is our client, but we're obviously here to be helpful, representing the city, steering you to the information, that might be helpful to you. And along those lines, there's a number of different resources, general resources that are super helpful. First of all, the city's ethics, documents. Talked about it, I hope a good amount tonight, but really short shrift compared to all that's there. And so I highly recommend that you go to this link and look at it. There's a lot of different council policies that govern behavior, again, above and beyond, the law. So our link there is for that. The city manager directives, I don't think are available publicly. They're private, but we kind of shared those with you where they applied. There's a lot of Brown Act resources that are really excellent. The Attorney General website, League of California City produces an excellent publication, open and public, their 5th version of that now. And contact me, or sorry, Nora, the city clerk, if you have questions about these rules, Form 700 filing. Nora's particularly adept at that as she administers it. Okay, closing ceremonies. I first want to give, I know we've gone through a lot. I know there's people from the public, here. I will tell members of the public if you want to stay and ask me questions afterwards. I'm going to stay till kingdom come. If you want to ask me some questions that we didn't get an opportunity to ask here. So I do want to ask, though, if there's any member of the public who wants to make a statement about the training that you received, today. Very good. That doesn't mean I'm not interested in talking to you about it, so by all means. Oh, Green, you want to make I'm sorry. That's a great way to do it. Do we have our microphone? Where'd our microphone go? Oh, there it is. And I'm sorry, in a little bit, I'm not going to time you. Here.
I just want to say I've sat in front of my laptop and done this before. This was much more interesting and illuminating. I have no interest, putting your interest above the public. I love it.
Yeah, very good. Thank you. Appreciate that. Any other green? Was there another green? A green or a red that you refuse to speak? Put up your red card if you refuse to speak. Thank you. Appreciate that comment. Again, I know it goes long. Ultimately, when I do it here again, if I'm allowed to ever do this again, I'll have it even be tighter and maybe even more relevant. But definitely appreciate folks' participation and the interest and the turnout, right? I've done this in front of a bunch of people before in the city where I was, but a lot of the people there actually had to, as Form 700 filers, that were employees, take it. That's not actually required here. The turnout of the employees here actually obviously care about this subject and interested in learning kind of what their responsibilities are, whether they have to take this training or not. Makes me very happy. Appreciate the culture of this organization in supporting that, and definitely the interest in the public in turning out for it too. So I think we've got awards somewhere. They're right over there, but we have to first decide who gets these awards. And the first source of the awards is the people who have done well on my silly quiz that I hope you enjoyed. I'm not going to remember what points I assigned to things. So again, I'm going to ask the collective ethics of the group, right? Come together and remind me of what the points are. So answer number one. Shout out answer number one. People know that one. You Good Men, number one. Classic, right? Classic. Who knows lead actors? Tom Cruise. Demi Moore. I forgot about Kevin Bacon. That one counts too. Okay, so 2 points for A Few Good Men, 1 point each for however many of those 4 actors that you named. Okay, so keep track. Keep track at home. Okay, number 2. Who knew number 2? The Paper Chase is right. Sorry, I should have. Everyone, well, we'll raise hands now. Paper Chase. The Paper Chase. Classic movie. Remember John Houseman as Professor Kingsfield as the character. Most people remember. It was written by a Harvard 1L about how nightmarish his experience was there.
What was it? Bull something used to do an advertisement for stock.
Oh yeah, he did. Yeah. Absolutely. And it's just a funny quote, right? Mr. Hard, take a time, call your mother, tell her brother. It's very, anyway. Okay, number 3. I think a lot of people know number 3. Legally Blonde. Love that movie. Love Reese Witherspoon. I love that's terrible, the scene where they tell her she has to come dressed in a costume, and she puts her bunny costume on, and it's not a costume party. That's like the meanest thing. They're so mean to her. But of course she rises above, and she's a super honorable, smart, person. So a very charming story. Okay, number 4. Who got number 4? Aaron Brockovich. Oh, I get a pretty good clue. All right, Aaron Brockovich. So again, 2 points for the movie. If you got Julia Roberts and Albert Finney, right, was the Albert Finney will count for 1 apiece. Okay, if people don't get number 5, it will break my heart in pieces. Thank you. To Kill a Mockingbird. Gregory Peck. Jean Louise is a good clue, right? But Jean Louise is not her. What's her name? What's Jean Louise's name? It's his daughter. Scout. Jean Louise is what her aunt, right? It's her aunt, calls her, Jean Louise. So Gregory Peck, right, he just lost the case. He's walking out of this very solemn, setting, and all of the, the black members of the community, right, who respect him so much because he was so respectful, to them and representative of them. They all stood, right, out of respect for him. And his aunt says, Jean Louise, you stand too. Your father's coming by. I'm even getting emotional thinking about it now. It's beautiful, beautiful moment, and one of the best books ever written by anybody. Number 6, My Cousin Vinny, another one, yeah. No, not in the movie. Joe Pesci and Marisa Tomei are there. Is that like a play? Yeah, no points for you on that. Okay. The next one I think is probably going to be tough. White man can't jump. I didn't say Woody Harrelson for this one. It's The Verdict. We got it down over here. It's The Verdict. Paul Newman, brilliant movie. He's a very a lawyer full of despair and angst. He's a lawyer definitely on his alcoholic, very rough movie, but Paul Newman's brilliant in it. He might have. Did he win an Oscar for that?
He got nominated.
Nominated, but didn't win.
He won for Color of Money.
That he shouldn't have gotten for. Okay, number 8.
People versus Larry Flint.
Wow, so a few people got that one. People versus Larry Flint. Woody Harrelson plays Larry Flint. Very obscure. I actually haven't seen that movie, but I know it comes up as the famous quote. Okay, I know people got number 9. Clueless. Clueless. 2 points for. I'm sorry. People versus Larry Flint. 2 points for the movie. 1 point for Woody Harrelson. Everybody got that one. But you get the point, so you don't have 0. And 1 point. 1 point for Ed Norton was the other main character in that. Next one, Clueless, right? Lead actors.
Alicia Silverstone, Paul Rudd.
Paul Rudd. Those 2 will count. So 2, 1, and 1 for that. Okay. I know people know it's Shakespeare, but who knows the play?
Henry VI, but it's
Part 1 or 2? Part 2. That's exactly right. Henry VI, Part 2. Okay. That's worth 2 points, right? Okay, now, who said it? Who said it? That's the only one you got? Do you know who said it? Character? Does anyone know who said it? It's Dick the Butcher. Dick the Butcher is one of the along with Jack Cade, right, the leader, they're trying to overthrow Henry VI. Okay, now for however many points I said, I need people to raise their hand. Why is it, remember Hardy, I think you were first, why is it that this actually is a line that praises lawyers and does not criticize them? People use it to criticize lawyers. Remember Hardy?
It was the only way they could take over control, was to get medical lawyers.
That is right. I'm going to give you credit. Not the 5,000 point credit, but a couple points credit. Yeah. The idea is, right, these are villainous characters, right? This isn't a righteous rebellion. They're bad, actors. And the thing they're trying to do is destroy the civil structure of whatever level of civil structure a medieval king, has and presides over his people. But there's something there. There is a rule of law. The lawyers exist. And their idea in their villainous attempt to overthrow is you kill the lawyers first, right? It's not something that Shakespeare is saying you should do. It's something that Shakespeare is saying is the thing that villainous people do. So thank you. Thank you for that. Okay. Who got 20 points or more? Wow, okay. Okay. Who got 25 points or more? 4 is there was a booby prize. 25 or more. Okay, so 25 and then more than 20. Who got 24? 23? 22? Okay, there's 2 22s. Okay, I think those are our prizes. 25 and 2 22s win the prizes. Now, yeah, yeah, you don't want a prize. Okay, okay, who got 21? Did anybody get 21 or 20? How about 19?
Who is it over here? Oh, yeah, okay, congratulations.
20? Okay, Liz?
Yeah,
Liz, there's another prize
there
up
you go,
here.
congratulations.
Okay, we didn't give you, if city employees are getting this, it might be stuff you have already. It's city swag. I think there's like a police department oriented one and a fire department oriented one. I think you got the police oriented one. So very good. Okay. I also want, there are some people who participate, who are good participants. Okay, that's okay. Yeah, very good. Hey, thanks everybody. I wanted to give a real loud shout out as people are walking out to everyone who helped put this together. As you can see, a lot of logistics went right into the setup, into producing the PowerPoint. Mandy Lopez, my assistant, Nora and her staff were super helpful. Please give Liz a round of applause. She had to do all of her regular work and put this together too. It really was a lot of work. But again, I want to thank all of you for your interest and your participation. I'm sorry? And yes, sorry, AB 1234 people. Sue is out there. If you toughed it out with all of us, you went above and beyond, and you get a certificate in order to show for it. So, oh.